Okay, good evening, everyone. It's 6:32 p.m. This continued hearing is scheduled for 6:30. This is the hearing that was continued from March 7th, 2026. When we concluded the last hearing, the applicant had presented David Babbitt. Mr. Babbitt concluded Mr. McHugh, I should say, concluded the direct examination of Mr. Babbitt. So now Mr. Babbitt will be made available for cross-examination. And as we did on the last time, anyone with party status who wishes to cross-examine Mr. Babbitt will be permitted to do so. As I think yes.
I just want to say, for anyone who wasn't here, I wasn't here last time, but when you're speaking, make sure that you're speaking into a microphone that's on, even if you're loud. The room system needs to pick it up, and we have quite a few people watching. So just push the little button, and we have a handheld microphone back here if somebody needs it. And if you're not speaking, try to turn it off. It helps mitigate feedback. Thanks.
Thank you. And as I had mentioned last time, this is your opportunity to cross-examine Mr. Babbitt, who is one of the applicant's witnesses. He has been qualified as an expert witness. This is not the time to make statements or to just get up and start making arguments or to start testifying yourself. This is the time to ask Mr. Babbitt questions. If the questions turn into speeches or arguments or testifying on your own, I will stop you at that point in time and redirect you to ask Mr. Babbitt questions. I can't remember whether we did it by just asking if there's anyone in the front row who has party status, but if there's anyone who has party status who wishes to question Mr. Babbitt, please raise your hands. Okay, please come forward. Please pull that microphone a little bit towards you if you can, and make sure it's on. Please identify.
Can you hear me? I can hear the microphone reverberating.
Yep.
It must be on.
Yes,
Okay?
you're good.
All right,
Please identify yourself,
certainly. My name is Rochelle Hittinger.
and you have party status.
Yes, and do you need my address, sir?
No, Ms. Hittinger is party status, correct? Yep.
Yeah, thank you. Yes, first name is Richelle. Last name Hittinger. Okay, Mr. Babbitt, I just want to start with a housekeeping matter. I know that you filed a report, and that report was marked as an exhibit during your direct testimony, right?
That's correct.
Okay. I will be referring during the cross-examination at various times to that exhibit. So I just want you to have it handy. In fact, we're going to start there because I just want to confirm your report states that this property contains an existing single-family dwelling on 7.804 acres. Is that correct?
Yes, that's correct.
Does this configuration comply with the property's R1 zoning classification?
I'm sorry?
Does that configuration comply with the property's R1 zoning classification?
I'm gonna object. The single-family dwelling and the lot that's associated with it is not the subject of this application. This application is solely related to the proposed senior living facility on Lot 2.
At the moment, there is only one.
I'm going to overrule the objection. I'm going to let him answer the question, but we're going to have to focus on what this conditional use application is and not on what the existing structure. Mr. Babbitt, you can answer the question.
As far as the minimum lot size, it does comply, and the use does comply.
Thank you.
Beyond that, I'd need to see a plan and a survey of the existing
That's all I
site.
asked you.
Yes, ma'am.
Thank you. So the property as a whole, in other words, the subdivision has not yet occurred, is that correct?
That is correct.
Okay, so the property as a whole, in its present configuration, can continue to be used in accordance with its R1 zoning classification, is that correct?
Certainly, yes.
Okay. Let's go to page 2, in which we have your photos. These photos confirm the large vacant house on the premises, as well as different foliage and a stream. Is that correct?
Among other things, yes, ma'am, that is correct.
Okay. And the house in this wooded area is consistent in appearance with the adjacent properties on Rydal Road, is it not?
In some ways, I believe it is. I don't know that it's possible to see the house very well from Rydal Road.
No, I'm asking you if it's consistent with the surrounding area,
In what way?
houses, trees.
Yes, there is a house on the property, and yes,
Okay.
there are many trees on the property.
Agreed. Okay. Same thing goes with Woodland Road. It's generally consistent with the surrounding neighborhood, is it not?
In terms of having a house and lots of trees on the site, yes, ma'am, it is.
Thank you. Let's look at that picture of that stream. That's a great stream, isn't it? Did you actually see that stream?
I did, ma'am, yes.
Did you have an opportunity to get close to the stream?
Just a few feet away, ma'am. My feet were almost wet when I took this shot.
Good. Was that stream clean and clear to you?
I
Did the
do
water
not-
look clean?
I do not recall what it looked like at the time.
Okay. Wouldn't it be an asset to have a stream like that on your property?
I'm going to object to the line of questioning. I just don't
Yeah, I'm
understand
going
the
to
relevance.
sustain that objection. That's not relevant to what we're here for.
All right. The property in its current configuration, it's surrounded on all sides by dwellings, by other houses, is it not?
The property is surrounded on all sides by single-family detached dwellings. Yes, that's right.
And there are different styles to those houses, is that correct?
In terms of architecture,
Yes.
yes, I imagine.
Well, you
some
saw
are-
it. What
Some
did
are
you see?
newer, some are older.
Yes. Okay, and some are colonials, right?
I would agree with that, yes, ma'am,
And
yes.
some are ranch houses?
I
and
don't
others are-
recall seeing any ranch houses.
How about split levels?
I don't recall seeing the design of the houses with that level of specificity.
Did you look at the houses on Durrell Road?
I drove up and down Durrell Road 2 or 3 times, yes.
Are they not split levels?
I do not know what type of the architecture those houses are.
These houses, they're no more than 25 feet in height, are they?
I'm sorry?
The houses are no more than 25 feet high, are they? That's a regular house.
They seem to be roughly 2 stories, 2.5 stories. That seems to be about right, maybe slightly taller than that.
Is a split level taller than that?
I think it can be, depending upon the setting, depending upon how deep into the ground it is,
Okay,
the
but
foundation is sunk.
then it would be lower, wouldn't it?
Excuse me?
If it were sunk into the ground, then the height would be lower, would it not?
Right, but if it were not excavated out into the ground, then it would be higher.
Right, and it would be no worse than having the height of a colonial house, correct?
In rough terms, I suppose that's correct. Yes, ma'am.
Okay, do you agree that the neighborhood that surrounds this property is a desirable neighborhood in which to live?
It appeared that way. Yes, ma'am. Absolutely.
You. Okay, I'd like to now go to the zoning map. Okay, we were told that we might have a zoning map projected onto one of the screens. Is that available?
Mr. McHugh, do you have any objection to the zoning map being projected?
I don't. I would just know, I don't think it's been marked as one of my exhibits, so if it needs to be
I
marked.
think we've,
I would be happy to have it marked as Hittinger 1.
okay.
Do you need a copy of the map, or are we going to have it projected?
I would just ask if you have an extra copy to provide one to Mr. Babbitt so that he has one. Never mind. I'll take one if you don't mind. Thank you so much.
Yes, ma'am.
Is this the, there's 2 within?
No, I want that one. I want the other.
This
I want
one?
that one. That's the one where we, yeah, that's a good one. Okay, are we all in agreement that this is at least part of the zoning map for Abington Township?
It appears to be the entire zoning map of the township. Yes, ma'am.
Okay. Did you consult this map at all when preparing your report?
Yes, ma'am, certainly.
Can you show us on this map the area Okay. Can you identify where the subject property is on this map? Let's do that first.
Using what tool?
Oh, that's a good question.
I have a big X with a circle on it on my zoning map.
Okay.
So yes, I
Could
am
you-
able to identify where the property is.
Could you please go up and show us where the property is on one of the maps on the screen? I think that's the best way to do it.
Mr. Babbitt, don't speak, because no one's going to be able to hear you. Just point and then return to the table, please.
Okay. Yes, we all know that it fronts out on Woodland. We all know that it also fronts on Rydal, and that the nearest cross street would be Durrell, would it not?
I believe that is correct. Yes, ma'am.
Okay. Now, tell us, from looking at the map, what is the area on the map that is designated as R1?
I'm sorry, I don't understand your question. The acreage of the R1
No.
district?
No, the location. How do we know what on that map is considered as R1?
It is designated by color. The
Okay.
R1 district would be a pale tan color, I suppose.
Okay, that's fine. That gets us where we want to go. So this R1 district, this extends far beyond the immediate surrounding area of the subject property. Is that correct? The
Yes,
R1
it does.
Thank you. Okay, now referring to the area which is north of Susquehanna Road, can you see Susquehanna Road there?
Yes?
And west of the railroad tracks.
Yes?
Do you see any areas in there that are zoned R2? Can you tell, first of all, do you see any of those areas?
Yes.
I'm going to object. I'm not quite sure the relevance of this line. I think it's understood and agreed that the property is zoned R1. I don't know what the relevance of other zoning districts and their proximity. The use was permitted in all residential zoning districts by conditional use.
I'm going to overrule the objection. I think Ms. Hittinger is trying, I think I have an idea of what she's trying to get to, but Ms. Hittinger, I'd ask you to get to it a lot faster than you are.
I'm doing my best.
I understand.
Okay.
So there appears to be two small areas of R2 zoning along the township boundary with what I gather to be Lower Moreland Township. In the areas to the northeast of Susquehanna Road and to the north of the railroad tracks.
Are these R2 areas close to the subject property?
Can you define what close means?
Adjacent to, within a short distance?
They appear to be within a mile or so, mile and a half maybe, at
Right.
most.
Okay,
That's relatively close. It's not adjacent, no.
all right. Do you see any areas in that part of the township that have any density higher than an R2?
In terms of, strictly speaking, residential districts?
Talking about this area that's zoned R1, and this area zoned R2, in the parameters that I gave you, are there any other denser uses that are marked out there?
Yes, there seems to be some land zoned R3, medium-density residential district.
No, I'm talking about where the boundary of the R1 ends.
Yes, ma'am, the boundary of the R1 district ends at the R3 district. I think that might be Huntington Road.
That's correct. Between Huntington Road and the railroad tracks, do you see any R3?
Between Huntington Road and the railroad tracks.
Yes.
Yes, possibly on, I guess that would be the other side of Susquehanna Road.
That's
but
not what
still.
I'm asking you. I'm asking you, in the parameters I gave you, from Susquehanna on the south, the boundary with the Lower Moreland Township on the north, the tracks on the east, and the R3, existing R3 on the west. Is there any other R3 or denser use in that area?
Yes, I believe so. There appears to be an area off of Woodland Road that would be zoned R4 high-density residential near Penn State Abington.
All right.
Penn State Abington?
Penn State Abington is not zoned, that's zoned CS, is it not?
It is in blue, which is the CS Community Service District. Yes, near that, to the left of that on the map, is an area with what looks like one loop street off
Correct.
of Huntington.
Correct.
Which appears
But
to be
that's
zoned,
it. There's nothing else there.
Other
This
than-
whole expanse is all R1, is it not?
other than that one residential neighborhood off of Huntington Road, yes, it appears to be R1 or other zoning districts as appropriate.
Okay. Are there any areas that are zoned AO in the area that we described within this R1 tract that's here? Do you see any AO areas there? Now, again, Mr. Babbitt, we're talking only within this designated area that is all R1, save for the two immediate portions that are minor portions zoned R2. Do you see any AO in there?
No, ma'am. The nearest AO district will be on the other side, the southwest side of Susquehanna Road.
Do you see any areas zoned BC in that same?
I'm sorry?
Do you see any areas that are zoned BC in that locale?
Business center?
Yes.
No, ma'am. The area zoned business center will be, again, west of or southwest of Susquehanna Road.
Are you aware of any 40-foot-high buildings in the same area that is zoned R1 that we're discussing?
Offhand, none come to mind.
During the past 10 years, are you,
Excuse me, I'll take that back. I believe the church spires of the church on Huntington Road might be 40 feet in height.
do you know that for a fact?
No, I do
Okay.
recall that there was a church with relatively tall elements to the building.
But you haven't
I
done
didn't-
anything to confirm that, have you?
No, ma'am, I did not measure the height of the church.
Mr. Babbitt, during the past 10 years, are you aware of the conversion of any property zoned R1 in the township to a commercial use?
No, ma'am, I am not.
Are you aware of the conversion of any R1 property in this same area to a life care community?
No, ma'am, I'm not aware of any.
Are you aware of the construction during the same time frame of any mid-rise apartment buildings or office buildings on any parcel that has been zoned R1?
No, offhand, I'm not aware of any.
In the past 10 years, are you aware of the construction of any townhouses or twin homes on any parcel zoned R1 in this area in Abington Township?
I do not know the date of construction, but there are townhomes on Penmore Place, I believe, alongside the railroad tracks.
Do you
and
know
that is-
do you know for a fact that they were constructed within the past 10 years?
No, I do not know.
That's what I'm
But-
asking you.
But I do know that they are townhouses and they are in the R1 district.
That's correct. But they were not constructed in the past 10 years.
I do not know that.
As an expert land use planner, is it your opinion that future development in the township's R1 zoning classification should include a mix of housing densities, like apartments and townhouses and twins?
I would say that the development of the R1 district should be in compliance with the zoning ordinance. And if there are elements of the zoning ordinance that permits such dwelling types, then yes, that would be entirely appropriate.
Do you
If not,
think-
then no.
Okay, do you think that is it your opinion that future development in the township's R1 zoning classification should include offices and shops and mixed-use buildings?
As a general rule, I would say no, that would not be appropriate.
Okay, let's go back to your report. In the third paragraph of your report, you state the subject site is roughly evenly divided between the Rydal Road frontage and the Woodland Road frontage. Is that correct?
Yes, ma'am?
So with a total acreage of 7.804 acres, you're allocating approximately 3.9 acres to the Rydal Road frontage and about the same acreage to the Woodland Road frontage, correct?
No, I would respectfully not say that that is the case. The number of acres in each area, I did not calculate. In terms of the frontage, it has roughly equal frontage on both roads.
All right, but could you say that the Woodland Road frontage is approximately 3.9 acres?
I'd need to see a site plan to be able to judge that, ma'am.
Okay. All right, give me one moment, please. All right, I'm just looking for a moment. Please bear with me. Okay, I'm looking at the third paragraph of your report. Could you please read the first sentence for us?
Under background, third paragraph under background,
Yes.
the subject site is roughly evenly divided between the Rydal Road frontage and the Woodland Road frontage.
So if there's a total of 7.8 acres, wouldn't half of that be about 3.9?
Again, roughly evenly divided?
Well,
I
you
did
s-
not make such a calculation.
Okay. But it would stand to reason that one half of 7.804 is somewhere in the neighborhood of 3.9 acres, would it not? The math would say that?
Yes, ma'am, I would.
All right, you also talk about the Woodland Road frontage as having an open field with few existing mature trees and woodlands, is that correct?
That is correct.
Is the approximately 3.9 acres, which we just discussed, fronting on Woodland Road, is that sufficient in size to build a single-family home consistent with the existing R1 zoning classification?
Objection to the relevance.
Yeah, I'm going to sustain that.
I think it's relevant because
He's not proposing single-family homes.
it's not a question of what he's proposing, it's a question of what the zoning code would provide. And if the zoning code would provide that that can go there, it becomes relevant.
I'm going to sustain the objection.
Did you ever discuss with your client the construction of residences on the property?
Objection to the relevance.
Sustained.
Okay. On page 258 of your transcript of your direct testimony, you were asked the question, Mr. Babbitt, were you engaged by the applicant in connection with this matter? Do you recall what your response is, or shall I read it out loud?
I reviewed the transcript, didn't memorize it. I apologize. Yes, if you could, please.
The answer that you gave is yes, I was, several times, period. Did any of the engagements that you mentioned, the several engagements, concern the use of the property for the construction of something other than a life care community?
Objection again to the relevance.
Sustained.
He's an expert.
He
He had discussions with this guy, he was engaged in different
We are here
times.
tonight for a conditional use application to propose a life care facility, not what could go there. And I understand your point about asking hypotheticals. If you want to ask him hypotheticals, we may allow that, but asking him what he discussed with his client, that's not what we're here for today.
Well, when he says he's been engaged several times, I can explore what those times were about, can I?
No.
He opened the door.
No, he didn't.
By saying that, I believe he opened the door
No.
for further questioning about what those several times entailed.
No. We are here today on the conditional use application. We're going to limit the testimony to the four corners of that application.
All right, but you said that you would allow a hypothetical about what could be built?
If you want to ask him a hypothetical about what else could go there, we'll allow that question.
Well, I mean, I would still object to that because,
And I'll overrule.
for the record, though, it's not a use variance standard. It's not showing that there is another use of the property. Life care facility is what is permitted. It's not an either-or analysis.
Understand, but those with party status should have the opportunity to, in case there's any argument that there's no other proposed use for the property, they should be able to ask those questions. But we're not going to go into excruciating detail on it.
Hypothetically, could a single-family residence meeting the R1 minimum lot size be constructed on the balance of that property?
Yes, ma'am, that's certainly true.
Can more than one single-family house be constructed within the acreage that's available on that property?
Solely by virtue of the acreage and not the frontage?
We're talking about frontage and acreage and minimum 1 acre lot size.
I'm not sure about more than one. I'd have, in terms of land area rather, yes, without question, there is room for more than one house. I'm not certain about how much frontage is along the line of the frontage of Woodland Road, whether that would
But
support.
the acreage would support more than one house, is that what you're saying?
The acreage would, yes, ma'am.
Okay. Let's go back to the Woodland Road frontage. Your report states that the Woodland Road frontage is at an elevation of 150 to approximately 180 feet, is that correct?
I'm sorry, which page are you on here?
It's the, it's within the fourth paragraph at the bottom of the first page of your report.
Yes, yes, ma'am, that's correct.
Okay. You also state in the third full paragraph on page 4 that the proposed buildings will comply with a maximum height of 40 feet as contained in the zoning ordinance. Is that correct?
Yes, ma'am, that's correct.
So then the proposed buildings will be at least 15 feet higher than the dwellings that surround the subject property.
I think that might be true of the dwellings on Dorrell Road. I do not think it will be true necessarily of the dwellings that are further uphill on Woodland Road.
But you indicated that the average height would be 25 feet. We discussed that already, did we not?
In rough terms, it might be 25 feet, but again, the houses to the north on Woodland Road are at higher elevations than the Woodland Road frontage of the subject site.
Right, but I'm not talking about the elevation. I'm talking about the actual differential in height.
Yes, the proposed buildings can be up to, I believe, 40 feet in height, yes.
Okay. So that would then be true with respect to the houses on Dorrell. There would be at least a 15-foot height discrepancy between the Dorrell houses and the buildings that are being built. Is that correct?
That is potentially true, yes, ma'am.
All right, let's talk about Woodland Road for a minute. Woodland Road, isn't it correct that Woodland Road slopes downward toward Valley Road? You were
It
out
does,
there.
yes, ma'am.
So then Valley Road would be at a lower elevation than the Woodland Road part of the property.
Yes, ma'am, that's correct.
Now, when you have two 40-foot-high buildings at a higher elevation than Valley Road, wouldn't those buildings be visible at the intersection where Woodland meets Valley Road?
Not necessarily. It would depend on how they are sited. It would depend on the extent to which existing vegetation in the area can be preserved. It would depend in part on the extent to which the existing vegetation occurs on lots other than on the subject lot. It would also depend, at least in part, on the extent of the proposed landscaping to be planted on the property. Whether you can see the buildings from any place other than directly between them or in front of them is not clear.
Are you aware of any tests that were done to determine the sight lines for these buildings?
I am not aware of any, no, ma'am.
Are you aware of anybody having been retained to perform the service of establishing sight lines for the building?
No, ma'am, I'm not aware of any.
Thank you. No further questions.
Is there anyone else with party status who wishes to cross-examine Mr. Babbitt? Might as well go right down the
Yeah, right down the line. We tried to make it easy. Let me see, I just want to get your report and your notice of testimony. My name is Kathleen Driscoll. I have party status, and I reside on Woodland Road. Good evening, Mr. Babbitt.
Good evening, ma'am.
I just want to establish, before we get into some questioning, the documents that you reviewed in preparation for your direct testimony. And I'm just going to go through, not necessarily comprehensively, but quickly, the documents you testified that you took a look at in preparation for evaluating the land use proposed on this property and drafting your report. I have that you looked at the Montgomery County Comprehensive Plan, the Abington Township Comprehensive Plan, the Abington Township Zoning Code, the conditional use requirements of that zoning code. I believe you stated you reviewed all the testimony that had been given prior to your testimony, and that would have been, I believe, Mr. Anderson, Mr. Elmore. You were actually present for Ms. Koza's testimony. You reviewed the reports that they prepared, as well as the drawings that were prepared by Cornerstone.
I reviewed those documents, but probably not every page of Ms. Koza's report. Probably not every page of Mr. Anderson's materials either. Some of them are highly technical that are beyond my scope.
Okay, all right. And your scope being land use development.
Yes, I'm a planner, I'm not an engineer, I'm not a traffic engineer.
All right.
But there are other documents as well.
Yes, there were other documents, but there was a number, riparian rights and Old York Road, Carter, that I don't know that are particularly germane to my questions
Well, the
tonight.
proposed comprehensive plan of the township as well.
All right, and that, as we know, has not been adopted by the township. So
That's
we're
correct.
dealing with their comprehensive plan that they adopted, I believe, in 2007. Is that correct?
I believe that is correct, ma'am, yes.
Okay, thank you. You yourself drafted a report that Ms. Hittinger just referred to, July 28th, 23. Is that correct?
Yes, that's the date.
Yes, and let me see. You addressed that report to Mr. Lior Barazani of Chevron Realty Partners LLC. Is that correct?
Yes, I believe it's called Chaverim.
Oh, I'm sorry.
Realty Partners.
Kaverim?
Chaverim,
I'm
yes.
sorry. Kaverim. Kaverim. You also, I believe, testified that you reviewed the application for conditional use that was filed by Chevron Realty Partners.
That would be Chaverim. Again, yes, I took a look at the application that was filed, I think, by Mr. McHugh.
Yes, and it was filed on behalf of Haverim Realty
Yes.
LLC, is that correct?
Yes.
And appended to that was the deed to the property that they're proposing to subdivide and then develop into the conditional use, which is the reason we're here tonight. And the owners of that property are all Haverim Realty LLC as well.
I do not know whose name appears on the deed.
Okay, well, let me give you a look at that.
Actually, I'm sorry, I do know. It says it right here. This is the application form for the conditional use application. This application form was prepared by Mr. McHugh, and it says that the owner is the same as the applicant, so therefore I would be led to believe that Chaverim Realty Partners LLC is also the owner.
All right, and it's just a matter of housekeeping. Am I correct? The principals of Haverim are David Mermelstein and Moshe
Objection to the
Barazani?
relevance.
Yeah, I'm going to ask you for what the relevance of this is.
Well, they're the principals in the company that owns the property that's here requesting conditional use approval. I think that's, who are the principals and the owners of the property? I think that's completely relevant.
It might be relevant, but I don't know how it's a relevant cross-examination question to Mr. Babbitt as a land planner.
It's a matter of housekeeping, and Mr. Babbitt testified that he did review the conditional use application. I'm just trying to establish who owns the property.
Okay, and I believe he just told you, so.
Okay. And the principals are David Mermelstein and Moshe Baranzani? Is
I
that
do
correct?
not know the principals of the company.
Okay. Okay, with reference to the Montgomery County Comprehensive Plan, you testified that at page 272 of your notes of testimony, that a comprehensive plan is a policy document only. It is not the law. The law is the zoning ordinance. You agree with that, of course?
Yes, ma'am,
You
certainly.
testified?
Yes.
You also testified at page 26 that in general, a county comprehensive plan is not a document or resource to be used to determine land use on a property-by-property basis. Is that correct?
Yes, ma'am, it is.
Now, Montgomery County is quite a large area, 487 square miles. It's the third most populated county in the state. 868,000 residents, 62 municipalities. Would you agree with me that it is possible that a planning code developed and adopted by the Montgomery, as a Montgomery County comprehensive plan might not always dovetail exactly with the best interest of a municipality like Abington Township, which is 15.5 square miles and a population of 58,500?
I'm sorry, I'm not sure what you're asking.
Yeah, I'm asking that you had testified on your direct that the application is consistent with the interest and intent of the Montgomery County Comprehensive Plan. And so I'm asking you, isn't it possible that a comprehensive plan adopted by Montgomery County may not always know or direct what is best for the citizens of Abington Township, a much smaller municipality with a much smaller population, particularly as it may impact an R1 zoning district?
If you are asking me, is there the potential for conflict between a county comp plan and a municipal comp plan?
Yes.
Or even between a county comp plan and the desires of a handful of people in a given neighborhood? I don't.
I'm talking about the municipality of Abington Township, yes, that they could be in conflict with the best interest of the township, as well as neighbors in a particular R1 zoning district, yes.
I suppose that is possible in a hypothetical situation, sure.
All right, thank you. The Montgomery County Comprehensive Plan, adopted in 2007. Again, you testified that the application,
You said the Montgomery County Comprehensive Plan?
Abington Township, I'm sorry.
The Abington Township
Thank you
Comprehensive.
for correcting me and correcting the record. The Abington Township Comprehensive Plan adopted in 2007. You testified that this application is consistent with the intent, purpose of that comprehensive plan. I would like, I'm assuming in your, in your area of expertise, land planning, you're very, very familiar with comprehensive plans, particularly this one, as you know, Abington Township so well. I would like to direct you to Chapter 4 of that comprehensive plan. It's entitled Natural Features.
I did not print Chapter 4. I only printed about 30 pages of the comprehensive plan in an effort to be environmentally conscious.
Well, I handwrote it.
Sorry?
I handwrote it. I didn't print it.
Handwrote it.
Yeah, even better.
That's admirable.
Well, let me suggest to you that on page 4.5, and I quote, land has developed in Abington Township to such an extent that all but a very few areas are urbanized. Would you agree with that statement?
As a generality, yes, ma'am, I would.
All right, and again, under natural features, 4.5, I quote, remarkable care has been taken in developing much of the township. The preponderance of shady, tree-lined streets, beautifully landscaped lawns, and significantly wooded properties contribute greatly to the beauty of the community. Would you agree with that?
Yes, ma'am, I certainly would.
And would you agree that that describes quite well, almost poetically, the area that we're talking about, the R1 district where the proposed use will be built?
Single-family homes, tree-lined streets?
Tree-lined streets?
Yes, ma'am.
Landscaped, peaceful, shady, lovely, and beautiful.
Absolutely, yes.
Thank you, thank you, thank you.
Ms. Driscoll, can you pause for 1 second? Do we know why we're getting this feedback?
I mean, if anyone has their mic on, it's not actively talking, I turn it off, but sometimes the room just
Okay.
bounces.
And
Sometimes
Mark,
have
you don't
like a
need to take
laptop
that.
right up next to the
Okay.
microphone.
All right,
so,
sounds good.
yeah.
And clearly, you reviewed and are familiar with the Abington Township zoning ordinance.
Yes, ma'am.
Okay, so in your direct testimony, you pointed out Section 102, General Purpose and Intent, subsection E, as pertinent. What I would like you to do is read for us Section 102, paragraph B as also pertinent to this situation. Do you have that in front of you, Mr. Babbitt?
102B, yes, ma'am, I do.
Yes, please.
102B says, and I quote, "Promote a land use pattern which recognizes cultural, historical, and natural features unique to each community and which provides for the separation of significantly different use intensities with transition zones where feasible to preserve community character."
Thank you. Also, you reviewed the zoning ordinance, Article 3, R1. Do you have that in front of you, Mr. Babbitt?
Yes, ma'am, I do.
Section 300, intent. Can you read that to us?
Section 300, intent, and I quote.
Yes, please.
In expansion of Section 102, general purposes and intent of this ordinance, it is the intent of the R1 low-density residential district to provide low-density, single-family neighborhoods.
On 1 acre lots, is that correct?
No, it does not say that.
It does
in the
not say
intent
that, but
section.
I'm adding a separate question. That R1 would speak to 1 acre lots, is that correct?
For single-family homes, yes, it would, ma'am. That's
Yes.
correct.
Thank you. All right, I believe, Mr. Babbitt, in your direct testimony, you stated that the application met all the requirements of the zoning code and met all the requirements of all of the conditional use criteria. Is that correct?
Yes, ma'am, it is.
I'm going to take a look at the conditional use criteria, section 1806. B2, could you read that to us?
Sections 1806, conditional uses, paragraph B2 simply says, consistent with the spirit, purposes, and intent of the applicable zoning district.
Which is R1, is that correct?
That is correct, yes.
And we just referenced the intent of the R1 zoning district. Is that
Yes,
also
ma'am.
correct? Just quickly, for comparison purposes, it's proposed that this property be divided into 2 lots. One will contain the existing manor house, which in your report you identified as, let me see, 4,957 square feet. Is that correct? By your report.
4,957 square feet built in 1924. That's simply according to the Board of Assessment records. I have no way to verify that.
Okay. And in your report, you also identify the proposed building number 1 for the E12 use, that's the assisted living and memory care unit, as being 20,850 square foot. Is that correct?
I believe that refers to the footprint. Yes, ma'am.
Yes, that's what I'm referring to. So that would be 4.2 times larger than the existing manor house that will be on Lot 1. Is that correct?
Approximately, yes.
Okay. Building 2, E10, independent living. You note that the plan is that it will consist of 11,894 square foot. Is that correct?
As a building footprint, yes, ma'am, it is.
Yes. And that's 2.4 times larger than the existing manor house on the proposed Lot 1. Is that correct?
I trust your math, ma'am. That sounds about right.
Okay, thank you. You also testified to the number of units and the beds that are going to be available between Building 1 and Building 2 on Lot 2, and I recall that the total amount of beds, therefore people, on Lot 2 will be 143 people. Is that correct? If there's 143 beds, the hope would be they'd be filled. Is that correct?
I believe my report says 143 beds, but I believe in the time subsequent to the filing of this application, the number of beds was revised down to 82 for the first building. So it would be
I'm talking about the combined buildings, Mr. Babbitt.
82 plus 55 would be 137, I believe.
All right, I'll have to look for that, but I'm sure it's 143, but 137, 143. For purposes of the question, you're proposing, or what is proposed, that with the development of these conditional use buildings on Lot 2, that you're adding to this neighborhood 137 to 143 residents. Is that correct?
Yes, ma'am, potentially, assuming full build-out and full occupancy, yes.
Okay, and of course, that's not including the staff that would be required, the vendors, people that deliver goods to the properties, landscapers, maintenance, et cetera. So we'll have more than 137 to 143 on that property at any given time. Would that be correct?
That it's possible, but some people during the day, when the large majority of the staff might be on-site, some of the residents of the independent living units might go on their merry way and leave the site. So
All right.
it's tough to say.
Okay, but what we do know, there are going to be beds that hopefully are filled. So 137 to 145. And how is that consistent with the intent of R1 for low-density housing?
Because it is a permitted use in the R1 district at these densities and up and includes this level of development, this scenario. It meets the zoning ordinance.
The question
Therefore,
really is, it may meet what the conditional use allows, but do you consider that low density?
if the ordinance does, I would, yes, ma'am.
Okay, all right. All right, again, the conditional use, section 1806. I'd like to refer you to 1806B4. Let me see, where is this myself? Which states that the conditional, well, it says, must meet all of the following general requirements. 4 is in conformance with all applicable requirements of this ordinance and all municipal, state, and federal codes applicable to the use or process in question. Is that correct?
Yes, ma'am, it is.
And I believe you testified that indeed the zoning ordinance was complied with in its entirety by the proposal presented. Is that true?
Yes, insofar as the application is for conditional use only, there may be other elements of the zoning ordinance that come into play later on in the process. Parking, steep slopes, things that don't get worked out until the land development phase. But at the conditional use phase, yes, it is my opinion that the application does meet the zoning ordinance.
All right. Mr. Babbitt, in fact, there is at least one piece of this application that does not meet the zoning ordinance. And I suggest to you that that's section 2312, I'm sorry, 2312, section 2312, off-street loading requirements. Would you agree with me that per this section of the zoning code, 2 loading docks are required at this site?
I did not print out the parking and loading requirements of the zoning ordinance. I do believe that the standards under the use provisions require parking and loading. I apologize. Under use E10 life care facility, paragraph number 3, special development standards, subparagraph H, drop-off area. Each building shall be provided with a minimum of 1 drop-off area. I don't know if that's quite the same as loading.
No, it's not. Section 2312 is off-street loading requirements, which states by land use or zoning district, the number of berths for these uses requires 1 loading berth for the first 20,000 square feet and 1 additional 20,000 square feet or fraction thereof. So the square footage that will apply to Buildings 1 and Building 2. One is in excess of 20,000 square foot, the other 11,000 some square foot. So you would require, per the zoning code, 2 loading berths. Is that correct?
Again, I'd have to take a closer look at that. It may. If so, I would suggest that that would be something that would be addressed at the land development phase of the application.
Well, at the time, Mr. Babbitt, at the time the application is filed and evaluated and considered, isn't it necessary that it meet all the requirements of the zoning code?
It would be necessary that it meets all...
Yes or no?
Yes, ma'am. It would be necessary that it meets all applicable requirements, the requirements that we know about, the requirements that apply to something as straightforward as a conditional use application. There may be other zoning issues that come up during the land development phase that no one has envisioned yet. This may be one of them.
This is not something that can't be envisioned. This is something that is required for each...
Objection that she's arguing with the witness now.
Please ask questions, don't argue.
All right. Did you, you reviewed, I know, the plans that were drawn by Cornerstone, and one is the one that depicts the buildings and the various accoutrements to those buildings, and it notes that there is one loading dock provided for 2 buildings. Is that correct?
I believe that is true, yes.
Okay. So, just hypothetically, if the code required that for 2 buildings of this size, 2 loading docks, that in fact this application is not in conformance with the zoning ordinance, was that correct?
I would go out on a limb and say that if the township decides that 2 loading docks are necessary for this development to move forward,
please?
then there
Yes
will
or
be
no?
2.
As it sits, as we look at it today, yes or no?
I do not know.
Okay, so if they don't have 2 loading docks and they're required, you don't know if that complies with the zoning code that requires 2 loading docks, is that
Right,
correct?
but it is one of the things, one of many things, that I'm confident that the application will comply with when the time comes.
It was
to
yes
look
or
at
no
those.
question as the application.
He is allowed to explain his answer.
Thank you.
And please
I
don't
apologize.
direct the witness, please ask the witness questions.
I got away with myself, I apologize. Okay, again, following up with, on the concept that the application is filed comports with all the zoning criteria for this conditional use. I want to just direct your attention to the dimensional requirements for the height of buildings in E10 and E12. I believe it's 40 feet, is that correct?
It appears to be 40 feet for both uses. Yes, ma'am.
Yes. And I believe on the drawings, on the plans, and I think it's the first plan, that the height of the buildings is shown as 37.5 feet. Do you recall that?
I do not recall the height of the building shown.
Okay. Now, if those buildings should exceed 40 feet, then they would not be in compliance with the zoning code and requirements. Is that correct?
That is correct. If the plan does not meet the requirements of the ordinance according to the definition of height and how that is measured.
Okay. I would like to, let me see, if we put up on the screen, it's Exhibit A3. It's a series of drawings, and it's sheet 1 of 6. Conditional use residential development plan.
Yeah, I think this was already,
Well,
this
your
is part of
exhibit,
his
yes.
report.
There's no objection to showing it, yeah.
Yes, yes, yes.
It's part of the...
Way. This is previously marked, right? Yeah.
No, I think that should be okay.
You want it right here, or which?
No, it's this
Oh,
one.
sorry, I just
You
meant
just
that.
had it, yeah.
It's a little touchy. So this is a touch screen if you need to come in.
Okay, I'll do my best not to touch it. Mr. Babbitt, if I could direct your attention to what's on the screen, A3, it's sheet 1 of 6, and I believe it's entitled Conditional Use Residential Development Plan. It was prepared by Cornerstone. Am I correct that in order to comply with the zoning code in terms of parking spaces, that the applicant needed to add a underground parking, pedestal parking detail to add 34 additional parking spaces to meet the code requirements? Is that correct?
I don't know about the intent, but I do know that pedestal parking is included in this application.
All right. And pedestal parking is a parking facility partially underground, partially above ground, which supports the structure above it. Is that correct?
Yes, ma'am, that's correct.
Okay. Can you tell, you see the little box on the right? That's the only, and you can correct me if I'm wrong, that's the only detail I found that depicts the underground parking detail.
I'm going to object. I mean, Mr. Anderson testified, it's been a while, but extensively as to the plans. There was a bunch of cross-examination on the preparation and the detail of those plans. I mean, Mr. Babbitt's reviewed them, but I don't know that there's really relevance to running through
Yeah,
plan details.
We'll overrule the objection, and we'll ask Ms. Driscoll to get to a point
Okay,
again quickly.
I'll get there as fast as possible. It's in connection with the height requirement of 40 feet. Can you tell by looking at that detail how much of that parking facility will be above ground and how much will be below ground?
No, ma'am, I cannot tell. I don't know if Mr. Anderson could. He might be able to.
All right. Would you agree with me there's no dimensions on that detail that would allow us to know what percentage of that, what the height of that parking, pedestal parking is above ground versus below ground? Would you agree with that?
I can't see the detail from where I'm sitting, but
Would you like to get up and take a look?
sure.
Thank you.
Okay. No, ma'am, there appears not to be any dimension regarding elevation. There are dimensions regarding the parking stalls, but not elevation.
Okay, so hypothetically, let's assume that the building heights are 37.5 feet. The height, the maximum height allowed for this conditional use is 40 feet, and that this pedestal parking garage protrudes 2 feet and 7 inches above the ground, which would be in excess of 40 feet. In that case, would this building be out of compliance with the requirements of the zoning code?
I don't think there's anything in the record or in his testimony that indicates that he performed the height measurements. He reviewed the conditional use plans. They indicate that the building height proposed is 37.5 feet. There's nothing independent of what Mr. Babbitt has testified to that would indicate that he's actually performed measurements and is able to testify.
Are you asking him to look at this plan and come up with his own calculation, or are you saying if it is 42 feet, is it above? Okay.
Exactly.
So.
Exactly. My point is,
If it's above 40 feet, Mr. Babbitt, does it not comply with the conditional use standard?
The answer is it's unclear because the definition of building height uses the phrase the average height of the highest roof surface. Okay. So there may be elements on top of a roof.
I'm going to overrule your objection for the time being and let these questions go. But again, asking Mr. Babbitt questions about a plan that he did not produce based on measurements that he did not take from, he was not the witness who presented this. We're only going to let that go so far.
yes, and I do understand your concern, but my point really is that Mr. Babbitt represented himself as an expert in certainly ordinances, and land use planning, and he has testified that 40 foot is the maximum height for this conditional use, and I hypothetically propose that if that pedestal parking facility extends higher than the allowed 40 feet, then this plan would not be in compliance with the zoning code. Is that correct?
And I think he answered that question
And the
by
answer to
saying...
that, yes. Thank you.
Potentially, it would depend on how the average height of the highest roof surface is measured.
Thank you. Thank you. All right, just following up on that, let's, parking. Again, there was testimony that a total of 118 parking spots were required, and a total of 118 parking spots have been supplied. That was based in part on an evaluation that they needed to have a parking space, one parking space per employee during the busiest shift on site. And I believe you said you reviewed Mr. Elmore's testimony. Do you recall him stating that that number of 19 employees was provided by the applicant?
No, ma'am, I don't offhand remember that testimony.
Is the applicant in the business of nursing home management and administration?
To the best of my knowledge, no, but the applicant certainly can hire an administrator or a management company or a development firm that takes care of all of that for them.
And have they done that in order to support this application, as showing it's consistent with the zoning ordinance in Abington?
I do not
Yes
know
or
if
no?
they've done that.
Okay, thank you. So if the estimate of the number of employees on the largest shift is low, simply adding even one more employee would cause this parking piece of the zoning ordinance to be out of compliance. Is that correct?
That is potentially true, and if it were out of compliance, I think the plan would need to change to reduce the number of beds or reduce the staff or what have you in order to come into compliance.
But on the face of it, as it sits, should more employees be required, then parking would not meet the requirements of the zoning code. Is that correct, yes or no?
Yes, it is.
Thank you. Okay, just very quickly, because we heard a lot of this last time. Traffic, section 1806G-5.
I'm going to object to anything on traffic. We spent almost all of a Saturday on this. Mr. Babbitt's testimony was he relied, he was here for Ms. Koz's testimony. I don't know that he gave any specific traffic opinions.
All right, I can skip.
This is a question about the traffic study?
No, it's a question about the number of vehicles that are going to be on the road. As the conditional use requires, there be no adverse impact to the community, and specifically mentions vehicular traffic.
But that's not his area of expertise. We had the traffic engineer here last month.
I agree, but he sat for the testimony. He's testified that this application meets all the conditional use criteria and requirements, one of which is there's no adverse impact on the neighborhood as a result of nuisance, odors, vehicular traffic, etc. So my purpose is simply to establish the number of added trips per day that will result due to the building of these two facilities.
Okay, I think, I'm going to overrule your objection. You can ask these questions, and then if we start to go too far, we can object again.
I do not recall the number of vehicles generated by the proposed development. I do not recall the number of vehicles existing on Woodland Road, but I do recall Ms. Koz's testimony that it was her professional opinion that the proposed development will not generate an undue amount of traffic, which will therefore not result in a problem for the neighborhood.
Do you recall that she also testified that this conditional use would result in 524 additional vehicular trips on Woodland Road? Do you recall that?
I do not recall the exact number.
Okay, well, I'm going to represent that was the number. So I would suggest, or I would ask rather, that whether or not 524 vehicular trips on Woodland Road cause a burden on the neighborhood is sort of in the eye of the beholder. Would you agree?
Oh, absolutely. It would depend on what time of day, what type of vehicles, all turning movements, there are any one of a number of variables involved in that calculation.
And I think certainly you would agree it would be important to the neighbors, wouldn't you?
I'm sorry?
Certainly, you would agree the 524 more vehicular trips would be important to the neighbors? Yes?
I would think any traffic would be important to the neighbors, yes.
Thank you. Okay. Okay, just a few more questions, really. All right. I believe you referenced in your report, you discussed in your report the steep slopes that exist on this particular plot of land. Is that correct?
Yes, ma'am?
I want to direct your attention to page 1 of your report. It's your final paragraph, where you note in the first sentence that unlike the Rydal Road frontage, the Woodland Road frontage is much more moderately sloped with almost no land in the steep slope categories.
Yes, ma'am?
Is that correct? Did you undertake any sort of study to determine just how much of Lot 2, is impacted by steep slope?
No, ma'am, I did not do
All right.
any independent study.
And you're familiar, of course, with the steep slope conservation district zoning ordinance requirements?
In general, yes. I believe Mr. Anderson was more focused on the steep slope requirements than I was.
Again, if this proposal does not comport with the requirements of the steep slope conservation district provisions, then it would not be in compliance with the zoning code. Is that correct?
Yes, ma'am, that is correct.
Okay. Are you aware that the steep slope conservation district defines both precautionary and prohibitive slopes? Are you aware of that concept?
Yes, ma'am?
And am I correct that, as a general matter, Section 1603A2 directs that steep slope mandates override requirements of the zoning district? Is that correct?
I do not have that provision in front of me, so I cannot tell.
All right. Let me see. It's part of the steep slope conservation district ordinance. I can show it to you. All right. I'm going to, can I approach the witness? I'm just going to show him my printout of steep slope conservation district section 1601, particularly A and B. If you could just read them into the record.
1601, A and B. This is section 1601, delineation of steep slope conservation district, paragraph A, precautionary slope. Those slopes greater than 15% and less than or equal to 25% measured over a 10-foot run. B, prohibitive slope. Those slopes greater than 25% measured over a 10-foot run.
Ashley, are you able to put up the page 2, which is the existing conditions plan?
Of the same exhibit?
Yeah, same exhibit. Thank you. Mr. Babbitt, I represent, this is Exhibit A3, introduced by the applicant, and it is the existing conditions map, or plan, rather, prepared by Cornerstone. You, I believe, reviewed this in connection with preparing your report and your testimony. Is that correct?
Yes, ma'am.
Can you tell me what the light gray depicts?
I'm going to object. Mr. Anderson testified to this plan. He's the one that prepared the plan, prepared the calculations. Mr. Babbitt didn't prepare it, he reviewed it. If it's just to get to the point that if the steep slope disturbance exceeds what's permitted by the zoning ordinance, the plan's not in compliance, I think he's already testified that's the case. Beyond that, if she's going to ask him about calculations that he didn't perform, I think we're going way too far upstream on this.
I think the question that's been asked, he can answer, so I'll overrule your objection. But I will say I agree that if, again, we start getting into things that Mr. Anderson, about his report, that he's testified to, we're not going to permit that.
All right, and again, I view it as going within the category of whether or not the application complies with the zoning code.
But
As a requirement of
you're
conditional use.
continuing to ask him to opine on a plan that he didn't produce, testimony we've already had based on calculations that he didn't do.
Okay. Ashley, are you able to put side by side the page 1, the conditional use residential development plan, with this existing conditions plan? Can you overlay one on the other, or?
I wouldn't be able to overlay, but I can try to.
And just so we have a very, or clean-ish record, there's an open question on the floor right now to Mr. Babbitt that you objected to and I overruled. Mr. Babbitt, do you remember what that question is?
No, sir, I do
Okay,
not.
Ms. Driscoll, can you repeat the question that you had asked? And if you can't, I'm sure,
I believe it was that she was asking between the gray and the dark gray to identify what those were.
okay. Can you?
Thank you.
Yes, the lighter gray appears to be existing. The lighter gray appears to be existing slopes between 15 and 25%. The darker gray, or almost black, I suppose, would be slopes greater than 25%.
Can you put the side to side, if you could? Thank you.
Page 1 and page 2? Is that one?
Yes.
Might get kind of small. See what you can.
That's not, here, let me show you. It's this one. Sheet 1 of 6, and that's sheet 2 of 6. Is that it? Okay.
Maybe. Just trying to see how to fit them both on the screen so you can see them.
Maybe I can work with this.
There's this, is there a specific?
No, this is good. This is fine. This is fine. Mr. Babbitt, Ms. Ashley has kindly put up on the screen what is the conditional use residential development plan, which is sheet 1 of A3, that's on the left, and the existing conditions plan, which is sheet 2. Can you take a look at those two plans and tell me, or take a look at the two plans, and isn't it true when you superimpose visually one upon the other, that part of the building is going to impede on both prohibitive use area in steep slope as well as precautionary area in the steep slope?
I'm going to object again. He didn't prepare the plans. This was testified to by Mr. Anderson. There's calculations regarding steep slope calculations and disturbance on the plan. This was a question for Mr. Anderson, which I'm sure was asked.
Okay, Mr. Babbitt, hypothetically, hypothetically, if the buildings proposed for the conditional use fall outside of the allowed percentages of precautionary and prohibitive land area and steep slope, would it be true they would not be in compliance with the zoning ordinance, specifically the steep slope conservation district requirements?
In your hypothetical scenario?
Hypothetical.
Yes, ma'am, that's potentially true.
Okay, just one last quick wrap-up. Again, with reference to the steep slope, Section 1605A sets forth a number of requirements when you provide a site plan for a building that is going to impact steep slope. And this is required to be submitted, this plan is submitted along with the application.
Does it say which application?
Yeah, the application for conditional use.
It says it's required for conditional use application?
No, for the zoning application.
Okay,
In this
for the-
case, it's conditional
For the
use.
land development application,
No, it doesn't say land development.
but it doesn't say conditional use application either?
No, of course not. It says the application.
Okay.
What the plan requires is to denote the location of all proposed and existing buildings and streets within the steep slope area. Was that done?
I'm going to object again. He didn't prepare the plan.
All right, my point is that if the applicant didn't.
Objection.
Oh. All right. Okay. Mr. Babbitt, the Steep Slope Conservation District ordinance requires that certain information be provided along with the application should the building, the proposed building be within a steep slope conservation district. Is that correct?
I reviewed the steep slope district actually for another application in this township years ago. I believe it does say that, yes.
Okay,
I
and
have
if-
not reviewed it recently, though.
And if the applicant did not provide all the information the ordinance requires with reference to the impact on the steep slope, then that application would not be in compliance with the zoning ordinance regarding steep slope conservation district. Is that correct?
Again, in your hypothetical, potentially it is, yes, ma'am.
All right. Thank you. I have no further questions.
Okay, it's 7:49. We're going to take a 10-minute break.
Yes.
And we're going to begin again at 8 o'clock. So we will be back in 10 minutes. Please, everybody stop talking. Please, everybody. It's 8:01. Please identify yourself and whether you have party status.
Barnett Satinsky, Barnett Satinsky, 1301 School Lane. I do have party status. Mr. Clark, I will preface this by saying I will be brief, hopefully be out of your hair in 20 minutes or so. And as a layman, when it comes to the issue of land use planning, I'll ask the questions in a form that makes fewer references to the zoning codes, but tries to put some flesh on the bone. Mr. Babbitt, I'm curious. You were retained to prepare your expert report and to testify. How much have you been paid or will you be paid for those services?
Again, objection to the relevance.
To know if the witness has any bias.
He's been retained as an
He's been retained
expert.
as their expert.
He is an expert.
Yeah, I'm going to sustain the objection. Please move on and ask questions that are relevant to the conditional use application.
On page 267 of your direct testimony, you referenced Rydal Park as well as some other facilities. The Rydal Park facility, and you've described it in zoning terms as being on the northwest side of Susquehanna Avenue. Does that facility abut the Baderwood Shopping Center?
It abuts a commercial use. I'm not sure if the facility directly adjacent to it is part of the Betawood Shopping Center or just maybe some other retail use that's next to the
Oh.
Betawood Center.
So-
If it's part of the conglomeration of retail along, the Fairway, I guess, and perhaps Valley Road as well.
So you're not familiar with the fact that Whole Foods is located most proximate to Rydal Park?
Yes, sir, I am.
Okay. And is that part of the shopping center?
Well, I'm not sure if it's formally part of the shopping center. It may just be a standalone store that's adjacent to the shopping center. I don't know that it matters that much, but I just don't know the arrangements of that
Okay.
facility.
Understood. Whole Foods has an extensive parking lot outside its facility, does it not?
It certainly does. I have parked there.
What did you buy?
I'm sorry?
What did you buy?
I don't recall. My father spent some time in Rydal Park,
Oh,
so.
okay. On page 271 of your direct testimony, you referenced Sunrise of Abington, the senior living facility that's located on Huntington Road where it intersects Susquehanna.
Yes, sir.
And you also testified on page 255 of your direct testimony that you are familiar with Abington Township, having grown up in Wyncote, and that you have been coming to Abington Township since the mid-1960s. Is that correct?
Yes, it is, sir.
Are you aware that the Abington Junior High School was located on the site of what is now Sunrise of Abington until the mid-1990s?
No, sir, I'm not aware of that.
So despite living in the local area and your familiarity with the neighborhoods, you don't know that Sunrise previously was the Huntington Junior High school?
No, sir, I don't recall that fact.
Are you aware how the fields across from Sunrise were used historically?
Would they have been part of the Y?
No. They were not. They were part of the school district property.
Oh, you don't mean across Susquehanna?
Correct, across Huntington.
Yes, yes. I am familiar with the fields there. I think some of them still exist.
And that they were used by the school district for the Abington Senior High football team to play on?
I do not know
You
which
don't
teams
know
played there.
the actual utilization?
I knew that they were playing fields, but I don't know which teams played there.
Do you know that the school district held graduation ceremonies there for its
I'm going to
seniors?
object. I mean, trying to give some leeway based on the surrounding area, but I'm not quite sure the relevance of the various historical uses of other properties that are not the subject of the property.
I'll let him answer this question, but at some point, we have to get to the point.
No, sir, I was not aware that graduation ceremonies were held at that facility.
Okay. And are you aware that behind the Sunrise facility is the Wells Fargo Bank, Gibraltar Wealth Management, and Custer Kitchens, which front onto State Route 611?
I am familiar with the bank. The other ones I can't say. There have been many retail and quasi-retail uses along Old York Road over the years, and they change every once in a while. I can't keep up with all of them.
Do you know how extensive the parking area is? And again, this is immediately behind Sunrise.
No, sir, I do not.
On page 267 of your direct testimony, you refer to the Penn State Abington campus. Is that correct?
I don't know the page number, but yes, that came up in direct testimony. Yes, that's correct.
And that campus, is it fair to say it's bounded by Cloverly Road, School Lane, and Woodland Road that encircle the campus?
Cloverly Road, School Lane, and what was the other ones?
Woodland.
Woodland, I believe that is correct. There may be another street in there, I don't know.
I represent to you that those are the only
Okay.
3 streets in the perimeter. Are you aware that a new academic building is being constructed by Penn State?
Yes, sir, I am.
And that building is wholly within the perimeter that I just described?
I believe it is on the campus, yes.
And just one quick historical question. Would you agree that what is now Penn State Abington was operated previously as the Ogon School for Girls, beginning at the turn of the 20th century, before the campus was donated to Penn State around 1950?
I'm not sure about the years, but I am familiar with the fact that it was a boarding school for girls.
Would you agree that the last significant building construction before the current academic building that's being constructed was the Woodland Building back in the early 1970s?
Do you mean on the campus, or do you mean part of the university?
On the campus?
Okay, I do not know when the buildings on the campus were built.
Now, you did state in your voir dire at page 255 that you were involved in the Lionsgate apartment project in which freshman dorms were constructed on Old York Road for Penn State?
Yes, sir, that's correct. I wasn't aware of the name of the facility, but I was involved in that application.
Am I correct that, to the best of your knowledge, there is no student housing on the Abington Penn State campus bounded by Cloverleaf School and Woodland?
I do not know if there is any other residential facility associated with the university.
You don't have knowledge of any such
Only the one
residence
that I know of. That's the only one that I know about.
on Old York Road?
Yes, that's correct.
Thank you. This topic has been covered. I'm just going to try to frame it in my own terminology. Do you agree that, with the exception of the residence on what has been referred to as Lot 1 on 1209 Rydal Road, with the exception of that residence, the remaining acreage is all undeveloped land at this point?
The remaining acreage of what? The subject site?
Yes.
That would depend on your definition of undeveloped.
How do you define it?
Oh, it depends on the context, is the short answer to your question.
Are there any buildings on it, other than the residence?
Yes, there are at least 2 outbuildings.
And what are they?
One is a garage located, roughly speaking, to the north of the existing home. When you face the existing home, it would be off to your left. And there is something that is referred to as, a wood playhouse that's near the stream in the southwestern portion of the site. It is a small, probably remnants of a shed used as a playhouse, presumably for children.
Thank you. Now, you're generally familiar with the proposed layout of the applicant's facility as reflected by what was previously marked Exhibit A3.
Yes, sir, I am generally familiar with it.
And do you agree that the loading dock, or docks as it may turn out, are approximately 50 feet from the rear of some of the Durrell Road properties? Approximate, I'm not asking for a specific measurement.
I have to see a full-size plan. I certainly can't read dimensions off of a page-size plan. I don't know how far it is, but it is in the area of the Dorrell Road properties.
Okay. On page 298 of your testimony, you contend that the proposed use of the property will not generate excessive noise. And you further contend there that everything makes noise, even a single-family residence. You recall that testimony?
Yes, sir, I do.
Is it your understanding that the applicant's proposed facility will utilize trucks for regular garbage and trash removal?
I assume that there will be some truck traffic accessing the site on a regular basis, yes, for trash, for deliveries.
How
that sort of
about food deliveries?
thing. Yes, potentially, certainly.
And how about supplies from outside vendors?
Yes, certainly.
Do you expect that the trucks or vans will use reverse alarms or backup beepers when they're backing up?
I'm going to object again to, this is stuff that was all covered in Mr. Elmore's testimony regarding functional operation of the site. It's not testified to by Mr. Babbitt at all during his testimony.
Mr. Clark?
I'm going to overrule the objection. You can answer the question, Mr. Babbitt.
Thank you.
If there are trucks on the site and they have sounds emanating from them when they are in reverse, then yes, there would be those beeping sounds, just as there would be when a truck accesses a single-family home and has to back up. Similar sounds.
And are those alarms or beepers used to alert people that a truck is backing up in the area from a safety standpoint?
Certainly, yes.
And is the level of sound in terms of decibels higher than the average level of noise or sound when it's used by these trucks backing up?
I could not answer that question, I'm sorry.
I'm going to show you, I'm not going to mark it as an exhibit, but I'm going to show you part of the township code, the ordinance on noise. I'll just hand it to you so you can refer to it.
Thank you.
I don't need one, thank you. I do not need one, no, thank you.
Now, if you turn your attention to section 1061A2, could you read aloud what the township has found in that subsection 2?
Section 106-1, paragraph A,
2.
A subparagraph 2.
Yes.
It says, and I quote, "The making, creation, and maintenance of loud, unnecessary, or unusual noises, which are prolonged, unusual, or unnatural in their time, place, or use, does affect and is a detriment to the public health, comfort, convenience, safety, repose, welfare, or prosperity of the residents and persons within the township."
You agree with that, don't you?
As a general statement, I would agree with it, yes.
And if you turn to section 106(3)A, listing prohibited acts, could you read that subsection A aloud?
106-3 prohibited acts, paragraph A says, and I quote, It shall be unlawful for any person to make, continue, or cause to be made or continued any loud, unnecessary, or unusual noise which either annoys, disturbs, injures, or endangers the comfort, repose, health, peace or safety of others within the Township of Abington limits.
And if you refer, and I'm not going to have you read these, but Section 3, uh, 3L1, the page may be flipped in the wrong direction. You'll find L on the back page. Yeah.
Yes, sir. What is your question?
And I'm going to be referring to section L, subsection 1. And that's describing generally air conditioning equipment and other mechanical equipment, which is installed or attached to a building. I understand that trucks are not installed or attached to a building. But it gives a range of decibels that the noise should not exceed. 55 decibels in certain instances, 70 decibels in others, and 60 decibels in other classes. Do you think that the township's specificity on decibel level informs as to the general prohibitions that you did read earlier?
I'm not sure I understand your question.
These are specific decibel levels, correct?
Yes, sir.
And there are general provisions that state the intent and prohibitions of Abington Township. And you've read those, correct?
Some of them, yes.
Yes. And what I'm asking is, does the designation of decibel levels somewhat inform as to what the township may consider to be excess noise?
I suppose in general, that would be true. I am not familiar with these provisions. These are not part of the zoning ordinance. These are freestanding provisions that apply everywhere in the township, regardless of zoning district. I have not reviewed these provisions before. I do not know what is meant by excessive noise. That sounds like it's a key phrase that might in fact be either defined or at least characterized somewhere else in the ordinance. So it's difficult for me to answer your question. In general, I would say that the ordinance and the township board that adopted it, obviously, intended to limit excessive noise throughout the township. That would be the purpose of this ordinance.
And if you refer to section 106-3M, that's again in another context, recreational motorized vehicles, but there the township code specifies not to be in excess of 73 decibels at a distance of 50 feet or more. You see that within that subsection?
Yes, but that only applies when the vehicle is operated on a public space or at or across the boundary of private property when operated on private property. I'm not sure that applies here.
I agree. But again, does the specification of decibel levels possibly inform as to what the township regards as excessive.
I mean, he's already been asked this, like, I think 3
It was
times
as
at
to a
this.
different, it was as to a different.
We're talking about ordinance
subsection.
requirements that don't apply to the project and whether they inform.
Almost the same objection. Please move on.
Now, turning to the subject of how the proposed structure will fit into the neighborhood. On page 296, and if you need it, I'll loan you a copy of the transcript. In your direct testimony, I'd like you to refer to certain lines that I'll ask you a question about. Starting in here, 296. On page 296, lines 17 and 18 of your direct testimony, you state, and I quote, "The architecture has not been determined yet," unquote. Is that correct?
Yes, sir?
You then take the next 17 lines from page 296, lines 18 to 25, and page 297, lines 1 to 10, describing how you contend the structure would be compatible with existing surrounding areas. Is that correct?
Yes, sir, that's correct.
Well, given your admission that the architecture has not yet been determined, isn't your testimony following that pure conjecture?
No. What I'm saying in this testimony is that whatever architecture is chosen, will need to be shown to be compatible with the existing neighborhood, or else the plan will not be approved at the land development phase.
But you can't opine on something that hasn't been designed yet, can you?
I believe I can, simply saying that I'm confident that the applicant, whoever designs the site, will choose a style of architecture that is compatible.
So the commission should rely on your confidence in this instance?
No, the Board of Commissioners should judge the architecture of the proposed building when that phase of this process comes about. And that would be under the land development approval phase, not under the conditional use phase.
There was testimony and questioning by earlier participants on the township's comprehensive planning objectives.
Yes, sir?
Do you contend that those objectives must be achieved on every street in the township?
No, sir, not at all. They are very general. Objectives are typically very general. Goals and objectives are.
In every
Township.
neighborhood in the township?
It's a general rule throughout the township. Does that mean every property, every street? It would be nice if every property and every street complied with the general objectives and goals of a comprehensive plan. I'm not sure that always happens.
You're not suggesting that every street have a facility similar to what the applicant has proposed, are you?
No, I am not, sir, no.
Do you contend that the objectives in the township's comprehensive plan override the township's zoning ordinances?
No, sir, I do not. In fact, it is the opposite that is true. The zoning ordinance is the law. The comprehensive plan is a policy document.
On pages 307 to 309 of your testimony. It's towards the end of your testimony.
Sir?
Starting at line 16 on page 307, you're asked whether you have an opinion as to whether the proposed development is consistent with the township zoning ordinance, and that's followed by similar question as to the township's comprehensive plan, the surrounding land uses, the specific requirements of uses E10 and E12, the specific requirements of the R1 district, and the conditional use standards and criteria in the zoning ordinance. And in each instance, you answered yes. You may have elaborated, but in essence, you answered yes to each of those questions. Is that correct?
Yes, sir, it is.
Do you contend that your expert opinions bind the commissioners, or that the ultimate decision on conditional uses is for the Board of Commissioners to make pursuant to their application of the relevant ordinances and evidence?
Oh, clearly, the conditional use application is subject to approval by the Board of Commissioners. I don't think anything that I would say, any report that I write, or any other consultant or witness would bind the Board of Commissioners to anything, the possible exception of the township solicitor.
Thank you. No other questions.
Sir, would you like this back?
Yeah, thank you. Yeah,
There. There.
yours. Yeah, I'll get it back.
Okay, thank you.
Oh, wonderful. Here you go. You bet.
Gail Weilheimer, Rydal Road, party status. Mr. Clark, before I begin with my cross-examination of Mr. Babbitt, I do want to note that when we began tonight's hearing, we had 40 residents from the community here in the boardroom. May I ask how many have appeared on Zoom? I know they can't testify via Zoom, but maybe we know how many have appeared on Zoom. I believe Ashley might know that.
Oh, how many attendees?
How many attendees are on Zoom? Yes.
Well, right now, there's 13, but, people... Oh, jeez, I'm sorry. I should know this. I was saying right now, there's 13, but people drop in and off every time. I don't know if it's the same 13 people that were here, that were here an hour and a half ago, so...
But right now, there's an additional
Right
13.
now, there are
Okay.
13 attendees.
Okay, if we can just note that on the,
Okay.
thank you.
But we'll also note for the record that we don't know if they're all those with party status, could be some township commissioners.
Understood.
Right, there are a couple names I recognize as like staff
Right, okay,
and
great.
commissioners, so I don't know how many of them are...
It is, you've now noted it for the record.
Thank you. All right, good evening, Mr. Babbitt.
Good evening.
So, sir, when you started your direct testimony, you were accepted as an expert in land use planning, correct?
That's correct.
And that is the area of your expertise as established both on voir dire and in your practice. Would you agree with that?
Land planning, which I would argue includes zoning.
Now, you did state in your direct testimony that you do not have any experience in the construction or operation of nursing homes or continuing care facilities as proposed here. That remains correct, doesn't it?
Yes, ma'am, it does.
So when you made comments in your direct testimony that you do not think the proposed property will generate excessive noise, odors, air pollution, you've never operated a continuing care facility, and you personally have no direct knowledge of this, correct?
I've never operated a continuing care facility. That is correct.
Right.
I
So since you have not operated a continuing care facility, you are not aware of the daily operations for a continuing care facility. Would you agree with that?
I will say I have some familiarity because of my parents having lived for years in a variety of facilities in Montgomery County.
Okay. Visiting parents is the same as running a facility and knowing the staffing and the operations and the needs of the facility? I
No,
think
it's-
that's a little different. Would you
No,
agree?
I would agree with you. It is different.
Okay.
But I have spent a good deal of time in a variety of facilities, and I have some familiarity of what happens there and what doesn't happen there.
Are you prepared for me to question you about the exact operation of this facility, or just talking about it from a zoning perspective? Well,
don't understand
you
your
were
question.
accepted as an expert, sir,
Yes.
in land planning. If you're saying you have familiarity with the operation of a nursing home or a continuing care facility, are you prepared for me to question you regarding the details of the operation of such a facility?
No, ma'am, I'm not an expert on the operations of the facility,
Okay.
but I
So
also
you're-
have some familiarity with them, having been there several times, numerous times.
But you can't take a perspective as you sit here today regarding the detailed operations, regarding noise, traffic, employees, as it relates to the requirements of the zoning code.
Not with any level of specificity, but I would liken it to a situation in which someone would say, I've never operated a super Wawa with gas pumps, which is an entirely accurate statement. But I've been to many. I have a pretty good idea of what happens at a super Wawa with gas pumps. I'm not an expert at it, but I kind of know what's going on at a super Wawa with gas pumps. It's in that vein that I answered that question.
Understood, it's in that vein. But regarding the intricacies that I questioned Mr. Elmore about, or Mr. Anderson regarding the operational details, as indicated by the objections of the applicant's counsel, you're not prepared to address those today, are you?
That's correct.
Your job here is to take the applicant's proposal and the applicant's representations as true and take a position as to whether they're code compliant, correct?
In part, yes. I would also say that if I felt that any of the applicant's assumptions or representations were inaccurate or outlandish, I would have said so. I have not found that to be the case.
Well, as the applicant submitted 2 separate buildings, the number of beds, the number of units, the number of parking spots, you're accepting that as being accurate for the purpose of your calculation, correct?
And when you say accurate, you mean, is this
Meaning,
what they intend to build?
This is what they intend to build,
Yes.
and you're making a determination of whether or not it's code compliant.
Yes, that's correct,
Okay.
yes.
You're not doing any further deep dive than that.
That's correct.
Okay. So during your direct testimony, you highlighted your familiarity with Abington Township, both having grown up here and having done work here, correct?
Yes, ma'am.
And while you've been asked some questions about which properties existed before certain structures, I'm just talking about generally. Would you agree with me that Abington has changed over the past 50 years?
Certainly, all communities have, well, not, I shouldn't say all.
Not all,
I would say
but-
all in eastern or central Montgomery County have changed.
Okay. When I ask you certain questions about your prior testimony, I'm going upon the review of your prior testimony. If you have any question about what you said previously in your testimony, you make sure to let me know so I could show you the exact page.
Okay, thank you.
Now, you stated in your prior testimony that the zoning codes meet the changing needs of the community. Do you recall that?
That the zoning,
The zoning codes, changes to the zoning code meet the changing needs of a community.
the amendments to the zoning ordinance, yes, zoning ordinances should and often do
Okay,
get revised in order to meet the changing world.
right. And you would agree with me that the needs of a community change over time,
Without question, yes.
okay? And the zoning code changes reflects the commissioner's adaptation of those needs as reflected in the code.
In theory, that is correct, yes.
Okay. Now, you stated very specifically and elaborated on this, the comprehensive plan should inform the zoning ordinance, and the zoning ordinance should be based on the comprehensive plan. Do you recall stating that?
Yes, I do. Ideally, that is the way it should work.
All right. Now, at the time the 2007 comprehensive plan, it was determined in that comprehensive plan that there was a need for additional senior living in the township, right?
Yes, ma'am.
Okay. And that was quite a while ago, 19 years ago?
approximately.
I can do that math. I'm not a lawyer. I'm not a mathematician, but I can do that math even as a lawyer. Okay. Now, to address the need established in the 2007 comprehensive plan, the township changed the zoning code a few years later to permit senior housing as a conditional use anywhere in the township on properties in excess of 5 acres, correct?
I do not know if you could say anywhere in the township. I can say.
It's under R1, R2, R3, and R4.
Yes. Oh, in those districts, certainly.
Correct. What
That's-
other residential districts exist in the township?
The apartment district is another one. There are mixed-use districts that have residential elements. I do not know if this type of housing is permitted everywhere in the township. I don't know if it's permitted, for example, in non-residential districts.
Okay.
But it is certainly permitted in the R1, R2, and R3, and R4 zoning districts.
On properties in excess of 5 acres.
I'd have to check, but I believe the requirements are the same regardless of the zoning district, yes.
Okay. So you referenced the census in 2000, which demonstrated this need. And you talked about the census in 2000 that demonstrated the need for increased senior housing. Do you recall that?
Yes, ma'am?
Okay. You would agree with me the census occurs every 10 years?
Yes, ma'am?
Okay. The 2000 census preceded the 2007 comprehensive plan, did it not?
Yes, ma'am.
Okay. At the time of the 2007 census, you testified that 19% of Abington Township was between 65 and 74 years old.
No, ma'am, that would be above the age of 65.
Okay, I'm looking at page, above the age of 65, I recall. Let me go to the page specifically.
I believe that would
I
be on
believe it's
page
270. I got it.
3-6.
I got it. It's okay, I'm here. Don't worry, I'm good. I'm on page 70, line 13 through 15. I will note that the 65 to 74, and it said in 75 and above age cohorts in Abington Township represent 19% of the population as of the 2000 census.
Yes, that's correct. That's 2 cohorts. That's basically everybody above the age of 65.
Okay. And you indicated that based on that, the aging population was going to need places to live, and that's what it said in the comprehensive plan, correct?
Yes, ma'am?
It has been 26 years since the 2000 census. I can do that math, and I presume you could follow along with me on that one, right?
Yes, ma'am.
All right. A separate census was taken in 2010 and 2020. Are you aware that according to the 2020 census, 6 years ago, the percentage of the township residents that are now over 65 years old has decreased?
No, I'm not aware of that.
So if I told you that the most recent census showed the percentage of being 11.71% of people older than 65 years old here in Abington Township, that shows less of a need of senior housing today than there was in the 2000 census that you referenced earlier. You'd agree with that?
I would if indeed you're talking about both age cohorts.
I'm talking about both cohorts. So if those numbers are correct, that shows less of a need than existed prior to the 2007 comprehensive plan, right?
Yes, that's correct.
Okay. Now, you referenced as a demonstrated need for senior housing the existence of Sunrise and Walnut Hill as the type of houses that is presently needed for the elderly. It's on page 271 of your transcript.
I believe I was referencing the comprehensive plan.
Right? Have you independently reviewed the senior housing available within a 10-mile radius of the proposed location?
No, ma'am, I have not.
So are you aware that there is not one senior living facility within 8 miles of the proposed residence that is full to capacity?
I'm not aware of that.
Are you aware that since the pandemic, the trend has changed from institutional residential use for our seniors to in-home use, to in-home care, as supported by Medicaid and Medicare funding?
I'm aware that that has become a more appealing option for some people, but that does not reduce the need for housing for seniors generally as the population overall ages.
Well, if the census statistics are correct, our Abington Township's population has not increased its aging population. But if the aging population hasn't increased, and now with a modification in Medicare and Medicaid funding that pays for family members and other caregivers to be in-home and care for their loved ones while they age at home, those would be two factors that modify the need for senior housing, wouldn't they?
Yes, that would be correct. Two factors that modify the approach.
Okay.
Not the only two factors, however.
Now, those factors are a change since the 2007 comprehensive plan for which this zoning change was reliant upon, correct?
That is correct, yes.
Okay. Now, when your client submitted this application a number of years ago, this type of facility was permitted as a conditional use under E12 and E10, correct?
Yes, ma'am, that's correct.
Are you aware that in 2023, the Abington Township...
Objection to the relevance of, assuming she's going to ask about a future zoning amendment that was, happened after the application was filed.
Mr. Clark, if
We're
I
gonna
may
let her-
respond.
We're going to let her ask the question first, and then we'll see what happens there. Maybe she'll surprise you, go in a different direction.
I don't anticipate, so if I may respond now. This witness testified about the need for this.
I've overruled him. You can ask
All
him the
right.
question, and then...
You want me to object again?
I want you to object again after the whole question
Okay.
gets out. Yep.
So if the Abington Township Board of Commissioners modifies their zoning code to reflect changing needs, well, let me go back a little bit. Changes in the zoning code may reflect changing needs of a community, correct?
Yes, ma'am.
And as you said, the township commissioners, if doing their job correctly, should modify the zoning code to reflect the needs of the community, right?
In theory, yes, ma'am.
So if there is no longer a need, as there was in 2007, for additional senior housing, the Abington Township Board of Commissioners may reflect that in the changes to their zoning code, correct?
If indeed you agree with the statement that there's no longer a need for senior housing in this township.
Well, there was an
That-
increased need in 2007. If there's now a decreased need, and the commissioners do not believe that's a continuing increase of need, they may reflect that in their zoning changes, correct?
Are you asking whether the township could change the ordinance?
I'm asking about the commissioners can reflect the needs of a community with the change of an ordinance, just as a general principle. You'd agree with that?
Yes, absolutely.
Okay. And are you aware that here in Abington Township, in 2023, the Board of Commissioners modified the zoning code to remove conditional care facilities and nursing homes as a conditional use everywhere in the township?
Now I'm going to object.
Okay.
And now can I respond?
And I'm going to overrule your objection because obviously the fact finder or the hearing officer here is aware of that change because I wrote it. And obviously the commissioners are aware of it because they approved it. So you can answer the question, Mr. Babbitt.
Yes, I'm aware of the ordinance amendment, yes.
And this would demonstrate a different perspective from the Board of Commissioners from when they changed the zoning almost 20 years ago, correct?
It might, yes, potentially.
Okay. Now, during your testimony, you talked about a number of properties as comparators to what's being proposed by the applicants.
As what?
Sure, as comparators, comparative properties to what's
Comparative.
being proposed by the applicant here.
Do you mean comparable properties? I'm not
Comparators,
familiar with the
comparable.
term of comparable.
Well, I'll go through them specifically. You listed first a number of other areas of use that would be permitted across Abington Township, and you highlighted these as showing that Abington Township is not just limited to single-family homes. But let me go through some of those. You mentioned riding academies and stables. You need at least 10 acres for those properties, correct?
I'd have to check the ordinance, but all I'm saying is that
I'm asking you if you need at least 10 acres for that use. It says it in the code, but go ahead and check it.
I'm not sure I have the pages in front of me that would allow me to check
I
it.
have mine. Would you like it?
Okay. Sure. Oh. In extra small printing.
It is. I was saving some trees, too. It's probably around pages 177 or so.
Signs. Use regulations. What were those uses? What's the letter?
You testified riding academy and stables.
Yes.
Those were the terms you used. You didn't use any other terms when you
Okay.
described it in the,
Then I will check my ordinance and determine what letter that would be. Okay, it's B4. That will allow me to zero in on the provisions of B4.
sir, I'm just using your testimony.
All right. C. A23, A25, B1, B2, B3, B4, here we go. A lot area of not less than 10 acres shall be required for any profit-making or commercial operations. This is under use B4, riding academy or stable.
Right. So at least 10 acres for riding academy or stable, correct?
If it is a profit-making or commercial operation, yes, ma'am.
Well, sir, you testified and listed a whole variety of things as examples that, to support this application of different uses across the township, as saying, as examples of, this is okay because we have lots of other non-conforming uses. So you mentioned riding academy as stables, but let's be clear. Do you want to know which page in your transcript you mentioned them?
Oh, I don't believe I used the term non-conforming, ma'am.
As, sorry, not non-conforming, but not residential.
Yes, that would be correct.
So, we have riding academies and stables, kennels where you need at least 5 acres, correct?
Well, let's do the same activity, find kennels, and then I will look it up.
Are you going to need my book still?
I will, yes, ma'am. Kennel is B2.
And sir, I'm
Probably on
going
the same
through what you gave as a foundation when you testified, so,
Right. My testimony did not intend to imply that these uses that are alternatives to single-family detached dwellings would be permitted on every single property in the R1 district. It was simply meant to provide evidence that other uses are permitted in the R1 district, which they
well,
are.
it's not just R1. These are township-wide if you have the right property. This is not just R1.
Well, my testimony was strictly speaking regarding the R1. I ran my finger down the R1 column on the 4 or 5 pages of the use table
Okay.
and listed the uses that would be permitted, whether by right, by conditional use, or by special exception, in the R1 district.
Let's keep going. You mentioned an adult daycare center. An adult daycare center could have no more than 6 people using the adult daycare center, correct?
I'd have to look that up, but I will be happy to do that. Adult daycare center.
While you're looking on page 179 of your transcript, no, I'm sorry, of the code, you mentioned a group home or personal care home. That needs special exception, right?
Can we ask one question at a time? I was back on adult daycare. Let's find that one first. Adult daycare is use A9A. A9A. C, use category E4 daycare. I love it when an ordinance is well organized. Use E4 daycare center adult. I'm sorry, what was your question again about adult daycare?
6 customers is the maximum that could be used, right?
In residential districts, that would be correct,
Correct.
yes.
You mentioned a number of areas that need special exception, and those would be a group home or personal care home, place of worship, emergency services. Those all need special exception. They're not by right, correct?
No, let's find them in the ordinance.
I just presumed you would be familiar with this since you did testify to it.
I apologize for not having memorized the Abington Township ordinance. So which of the uses now we're talking about?
You testified as to group home or personal care home. If I can help you out,
Group home or personal
that's-
care home.
That's page 179.
Right. According to the table, group home or personal care home is use E7, and it is permitted by right in the R1 district.
It's special exception.
No, ma'am.
You think it's by right? We'll talk about that separately. Place
sorry?
of worship, page 183. Needs special exception.
Place of worship, according to this use table, that would not require a special exception. It would require a conditional use in the R1 district.
Okay. And for conditional use, you have to comply with all aspects, correct, of the code. You can't need variances.
Right. That would be all aspects of the zoning code that are applicable at the time of conditional use application.
Okay. Let's go through the zoning code. My research shows Abington Township first approved its comprehensive municipal code on March 11th, 1976. It was effective April 1st, 1976. Do you have any reason to disagree with that?
Yes, ma'am. I believe it was, the first zoning ordinance in this township was decades before this, probably in the 1950s.
Not the zoning ordinance, but the comprehensive municipal code. So the big thing we're
Okay.
putting together.
I do not know when the comprehensive municipal code
Okay.
was dated, but the
There were
first
bu-
zoning ordinance was
There
from
were
the
building
1950s.
codes before this.
I'm sorry?
There were building codes and zoning ordinances, but as far as a comprehensive code.
Okay, I do not know when the comprehensive code was established. The zoning ordinance, I believe, was first established in this township in the 1950s or earlier.
And when you talk about, you gave a number of comparative properties that were in the middle of residential districts and indicating that as this is there's nothing wrong with this property that's being proposed because there are so many others in the township that are also in the middle of a residential district. Do you recall that testimony?
Yes, ma'am, I do.
Now, you would agree with me inserting something like this facility, an apartment building, a nursing home, anything else in the center of an existing community is different than when a community builds itself around an existing use.
No, ma'am, I would disagree. The end result is the same. This is what is on the landscape in that location.
So you don't think it has a different impact to the neighbors, the neighborhood, the composition, the effect, as far as which one is built first?
It may have decades ago, but
Well,
in current times, the fact that there is an institutional use next to residential development, that's what it is.
well, let's talk about that.
Okay?
So you mentioned a number of properties, and you use those as examples of being in the center of a residential area. You mentioned Penn State Abington. Are you aware of the fact that Penn State Abington was built in 1915 before any zoning code here in Abington?
Well, I think some buildings may have been that old.
I'm asking you about this. I'm asking you to answer my specific question. Are you aware that Penn State Abington was built in 1915 on 45 acres?
Maybe one building or two buildings were, but not the entire campus, obviously.
Okay. The structure was built, initiated in 1915, 45 years ago. And are you aware that the majority of the surrounding homes were built in the 1950s, 60s, 70s, and 80s, after the existence of Penn State Abington?
I think that some houses may have been built before then, and some houses may have been built after then. Some of the houses in this neighborhood are actually older than 1915. So
You see,
obviously,
this-
there are some houses in the neighborhood that were built prior to Penn State. And clearly, there were elements of that Penn State campus that were built after the surrounding homes were built, because not every building is from 1915 on that campus.
The structure, the physical boundaries of Penn State Abington have existed prior to the development of everything but the manor houses there. Are you aware of that?
The physical
The
boundaries?
The physical boundaries. It actually far exceeded what exists now.
I'm a little bit confused. You're asking about the buildings or about the boundary of the campus?
How about the fact that Penn State was here before the majority of that neighborhood? Would you agree with that? That neighborhood being developed.
I don't know, ma'am. I think some of the campus may have predated the houses, and other elements of the campus were built after those homes
So your
were there.
indication, and you took great pride in talking about, and we're going to go through a lot of them, all of these different areas in Abington that have residences around them, and giving the indication that this works with a neighborhood as if they were put in the middle of the neighborhood after the neighborhood was established. But that's not actually true with the list of properties that you provided. So let's go through others. Meadowbrook School was built at 1919 on 16 acres. The surrounding homes were built in the 1970s. Meadowbrook School, that building was built...
Objection, if she's got to have a question. I mean, I understand she's laying foundation,
I'm asking the
but-
question.
I think she's getting to it.
Okay.
So, yep, overruled.
So Meadowbrook, are you aware of the fact that Meadowbrook School was built in 1919, almost 20 years before the adjacent homes were built?
No, ma'am, I'm not aware of that.
Okay. You mentioned the Meadowbrook Farms. Now, the Meadowbrook Farms started as the Coltswood Manor House. Are you aware that that property was built in 1936 on 25 acres?
No, ma'am, I do not know those facts.
Okay, so are you aware that the surrounding homes, majority of the surrounding homes to that location were built in the 80s?
No, ma'am, I was not aware of that.
Okay. And that only recently, as in the past 15 years, was that property converted to Meadowbrook Farms, on the same physical structure as the Manor House. Are you aware of that?
No, ma'am.
Okay. Holy Redeemer Hospital. You mentioned that as one of the areas you highlighted. That was built in 1959 on 45 acres. Are you aware of that?
I am quite sure that there are buildings on that campus that are much newer than 1949.
Wasn't my question. The original structure was built in 1959 on 45 acres. Are you aware of that?
No, ma'am, I was not aware that the original structure was built in 1949.
And are you aware that the majority of the surrounding homes were built in the 70s and 80s?
I am aware that the majority of the homes were built later, yes, especially Meadowbrook Apartments.
Where Meadowbrook Apartments is located, and you like highlighting certain things, and I know you like adding information that's not specific to the question that's asked of you, so let's get into that. Meadowbrook Homes is on Huntington Pike, a very busy road, correct?
Yes, ma'am.
And that's in a different residential zoning district, correct?
Yes, ma'am.
Okay. Likewise, when you mentioned Rydal Park is in a different residential zoning district, correct? It's in R7.
I have Rydal Park on my zoning map as being part of the AO Apartment Office District, is that correct?
It is not the R1 district and is not part of Ward 1. It's Ward 7. Are you aware of that?
I am not aware of which ward it sits in.
Okay.
The zoning map does not actually have an R7 district.
But it is designated as AO, not R1, correct?
That's correct.
It is buffered by the shopping center and Susquehanna Road, right?
I would not use the word buffered, but is bounded by those facilities, yes.
And Susquehanna Road is one of the busiest roads in Abington Township, a two-lane road. It's actually a state road, correct?
That is correct.
And Susquehanna Road separates this community from Rydal Park.
Yes, ma'am, that's correct.
Okay. You also mentioned the townhomes at Penmore Place. Penmore Place being townhomes and that being something that bolsters this application. Penmore Place is also buffered by Valley Road and the railroad, correct?
Yes, ma'am, there's some open space along the creek along Valley Road.
But it's not in the center of a single-family home residential district, correct?
That's correct.
Let's go back to your list. You mentioned St. Joseph's Manor, St. Joseph's Manor being now in the center of a residential community. Are you aware that that was built in 1937 on 45 acres?
No, ma'am, I was not.
Okay. Are you aware that the surrounding homes were built in the 70s and 80s, 30 to 50 years after the construction of that?
No, ma'am, I was not aware of that either.
Okay. You mentioned Rydal Elementary School. Rydal Elementary School was built in 1959. Were you aware of that?
No, ma'am.
Were you aware that the surrounding homes for Rydal Elementary School were built in the 1970s, and then another neighborhood was built in the 1990s?
No, ma'am, I was not aware of that.
So long after Rydal Elementary was constructed. St. Hilary of Poitiers, you mentioned that property as being in the center of a residential neighborhood. Are you aware that that was built in 1962?
No, ma'am.
And are you aware of when the surrounding homes were built?
No, ma'am.
You have no idea they were built more than a decade after the church was established. You mentioned Redeemer Sisters Chapel. Okay, that was built in conjunction with St. Joseph's Manor. Do you know when that was built?
No, ma'am, I do not.
So if I told you it was 1937 on 45 acres, you have no reason to disagree with me?
That's correct.
And can I presume you don't know when the adjacent homes were built?
That's correct also.
So if they're built in the 1970s and 1980s, you're not aware of that?
That is correct.
Okay, there are 3 more properties that you mentioned in your testimony. Brookside Roslyn Nursing and Rehab Center. And you highlighted this one specifically because of the similar facility. Are you aware that that was built in 1960?
No, ma'am, I don't know when it was built.
Okay? And that the surrounding homes were built in the 1970s and 80s, 10 to 20 years after the facility was constructed?
I was not aware of that, ma'am.
You mentioned Phoebe Wincote property on Fernbrook Avenue. Do you know when that was built, the original mansion?
Not offhand, no.
Okay, told you 1890. You have no reason to disagree with that?
I think a very small portion of the building may have been built in 1890, yes.
It was modified in 1928 and then again replaced in 1968. Were you aware that the surrounding residential community was not constructed until starting in the mid-70s and going into the 80s?
No, ma'am, I believe that is not accurate. There are homes across Fernbrook Road, and I say this having been in many of those homes that predate the turn of the 20th century.
Your last comparator that you gave was Abington Baptist Church. When was that constructed?
I do not know.
So 1961. If I told you that, you have no reason to disagree with me.
That is correct.
And you have no reason to disagree with the homes that are surrounding it were built about a decade after that, correct?
I have no reason to disagree. That's correct.
So when the neighbors are, one of the factors in conditional use is how it comports with the character of the neighborhood. And I'm going to take my book back so I can
Sure.
see exactly what wording. There is a difference. Sorry, Mark, I'm not at the microphone. There is a difference when you're talking about whether something comports with the character of the neighborhood. If the neighborhood exists before the invasive structure, or if the structure exists and the neighborhood is built around it, as far as whether it comports with the character of a neighborhood.
I would say from the perspective of taking a look at the zoning ordinance and the zoning map and seeing that there are institutional or quasi-institutional uses that are surrounded by residential neighborhoods, no, it does not matter.
I'm not talking about what the zoning is. When we talk about what's the character of a neighborhood, what does it look like? What are the houses? What's the size lots? What do they appear like? What is the composition of the neighborhood? When you think about what is going to fit in with a neighborhood, when we use the words, I'm using a colloquial term for the conditional use application, you have to consider what's there when you think about how this proposed use is going to comport with that character, correct?
In part, that's correct, yes.
Right. So versus if a structure, a church, a hospital, another a school was already there and the community was built around it, that's a different analysis.
I think perhaps it may have been at that time, but today, decades later, I don't think there's a significant difference between the two.
In order for the applicant to prevail in their proposal here, they must be code compliant, correct?
Yes, ma'am.
If they need any variances, that is not a conditional use application, correct? That doesn't comply with conditional use.
I believe that would be correct,
Okay.
barring the successful application to the zoning hearing board for a variance prior to the submission of the conditional use application.
And there could be no probability of great harm from the application in order to comply with conditional use.
That's correct, in general.
And if the applicant cannot meet all of the conditions in the zoning code for conditional use, their application fails, correct?
That would be correct.
Okay. No further questions.
Is there anyone else present who wishes to question Mr. Babbitt? Okay.
My name is Steve Booth. I have party status. Do you need the address? I can,
No.
okay. One super quick follow-up to the excellent, humble opinion, job Gail just did. When you talked about the properties that you were listed, Holy Redeemer, Meadowbrook, St. Joseph's, Rydal Elementary, St. Hilary, Redeemer Sisters, Roslyn Nursing. You gave them all, as Gail mentioned, as examples. How many of those are currently in R1 right now?
Penn State Abington is not R1. Meadowbrook School is not R1.
Holy Redeemer Hospital?
Meadowbrook Farm is...
I'm not talking about Meadowbrook. This was a separate section of your testimony. Holy Redeemer Hospital,
is not R1.
okay. Meadowbrook Apartments,
Meadowbrook Apartments would not be R1.
St. Joseph's Manor,
That is unclear from the zoning map. It looks like it could be, at least a portion of it be in R1, yes.
okay. I would submit that it's not. I looked it up. We can talk about it. Rydal Elementary,
I think the elementary schools are not zoned residential zoning districts.
Redeemer Sisters,
Redeemer Sisters, Morden Road. I believe that is zoned R1, yes.
it's not that section there off of Marlin Road and Huntington that's not R1? That's where the building is?
I believe it extends further back away from Huntington Pike than just the frontage
Okay.
properties.
And then St. Hilary,
The church, St. Hilary, I believe is not zoned R1.
correct. So question I have for you is you mentioned all these and your testimony was that they were surrounded by R1. And you used that as an example of something that would be a comparative, whatever the cool word Gail used, to this example here. In fact, you testified that this is typical, to show that this is typical, this is usual, this is customary. Mr. McHugh's been very focused on keeping us focused on the conditional use. I would submit that these properties are adjacent to R1. Would you say that's correct?
In some instances, yes, that would be correct.
Most of them were not R1, so they're...
Yes, that's correct.
You're saying they're surrounded by R1, so they're adjacent to R1. Unless I miss a meeting, this proposal that the applicant has, you're not talking about placing this facility adjacent to R1, correct?
Well, it's within and adjacent to R1, it's both.
Well, it's in R1, to be
Yes.
very clear. Because you testified earlier that, as you can look at the zoning map, it's kind of like this explosion of color. There's a lot of different zones here, but this is not in a non-R1 zone you're proposing. It's inside of an R1 zone.
That's correct.
So your examples, I'm trying to understand if Mr. McHugh's keeping us focused on the conditional use, you're not asking, the applicant's not asking to have this adjacent in another non-R1 facility, correct?
I'm sorry, I don't understand
You're
the
asking
question.
it to be inside of R1,
Yes.
in an R1.
Are you
So-
asking whether we are asking for a rezoning, a zoning?
No,
map
not at all.
amendment?
No. I'm saying that all your other examples were adjacent. This, what you're proposing is inside. So they're not applicable comparatives at all. Gail did a great job on the age. You're asking this to be in an R1 zoned, what do you call that, area, correct?
Zoning district, yes.
Right.
We are asking that it be in the R1 district
Yeah,
because.
all
that's
your
what-
other examples were adjacent to R1.
No.
So they're not comparatives, correct?
I believe they are, but I'm not using them in that way. They are comparables to prove the point that it is quite typical, usual, customary to have these types of quasi-institutional uses adjacent to, or even sometimes surrounded by, residential development, virtually regardless of what zoning districts those institutional uses themselves may be in. So the fact that the church is, that's a bad example. The church, I believe, is zoned R1. So Penn State Abington. Penn State Abington, at some point, may have been zoned R1. My point is, it is an institutional use. It is surrounded by residential development, and people have come to grips with it. People have accommodated the campus over the decades that it's been there, and this is quite a typical, usual, customary feature of the built environment, at least in southeastern Pennsylvania.
And to be clear, that's, as Gail pointed out, the example that what the applicant is asking for is to place it inside of a current R1. That's the whole conditional use, correct?
Yes, that's the way it is currently.
Thank
yes.
you. So the other thing I want to talk about is, sorry, find my notes here. When you talked about the conditional use, and I apologize, I didn't make a bunch of copies, so I can read, I cut and pasted, I swear, we can take a look.
Which section are you referring to? I may have that printed.
Okay, so in section 1806, it states, the burden of proof.
Definitely have that printed.
Okay.
Yes.
It talks about that the burden of proof in a conditional use application shall be on the applicant to establish that the proposed use meets all the requirements and objectives of this ordinance, correct?
Yes, that's correct.
So I just want to talk about one particular area, which is you talked about one of the four, actually half of one of the four conditions, is that an improvement which is not detrimental to the properties in the immediate vicinity, correct? You're aware with
Yes,
of
that's
that?
correct.
Okay.
That's paragraph or subparagraph B3.
I absolutely believe you. Thank you. You offered one piece of evidence on that, which was the dimensional requirements of E10 and E12, correct?
I don't recall what I mentioned, but as evidence in my assertion that the proposed development will not be a detriment to the properties in the immediate vicinity, I would cite the zoning ordinance, which permits these uses in the R1 district on 5-acre lots, and we are in compliance with all the provisions of these, of the zoning district.
Thank you. And then you stated this is probably the single most important way the township has ensured that the impacts of the proposed uses will not be detrimental to the surrounding land uses. I can find the quote. It's a quote.
Right.
Would you agree with that?
Meaning
Okay.
that the township knew that there would be impacts from a potential institutional use or senior housing facility within an R1 district, and therefore they required a larger lot, a deeper lot, a wider lot, and deeper setbacks all around. Yes, that's correct.
So the E10 and E12, you mentioned before you weren't aware, I think, and then if I heard it wrong, I apologize. You weren't aware if they were allowed in other zoning districts, is that correct?
I believe they are permitted in the R1, R2, R3, and R4 districts.
Okay, as conditional use.
In those 4 districts, yes, that's
Yeah,
correct.
That's why
Conditional
that's why we're all here.
Conditional use in those 4 districts.
Okay. They are allowed in apartment office as a special exemption, something called Main Street High, and then the something industrial Glenside. They are all allowed by right, correct?
Well, the use E10, and I apologize, this is very small print, but use E10 is permitted by special exception in the AO district, by conditional use in the CS district, by right in the MS-H district, by conditional use in the R1, R2, R3, and R4 districts, by right in, this looks like the
SIG, yeah, it's Special Industrial Glenside, or I'm with you.
Yes, it would be by
Yeah, I
right
had
in
to look
that
it up.
district.
Mr. Booth, please don't speak over the witness.
Oh, I apologize.
While he's speaking.
I'm so sorry.
Until he's done.
While we're taking a pause, I'm going to object in the sense that I'm not sure what the relevance is to identifying all of the districts that this use is also permitted in.
I'll be getting to that, I promise.
Okay, I think We'll wait till the next question and then
Okay.
make the objection again.
So your assertion is that the township did these setbacks for the conditional use, but this is a established use in the zoning documents. And what is the difference between the, excuse my phrase, the language, the dimensions between conditional use that they showed and also in the allotted uses? Because in the zoning document, it lists E10 and E12, and under E10 and E12, it lists the dimensional requirements. Is there a difference between the conditional use language and the standard by right language?
I think if I understand your question, the answer would be no.
Correct.
Let me explain that.
Right.
I think if you're asking me, does the ordinance require 5-acre lots with a certain lot width, lot depth, and setbacks in every zoning district where use E10 is permitted? I believe that is correct.
Right.
It doesn't vary according to the zoning district in which it is permitted.
Correct.
Whether it's permitted by right or by by conditional use.
Thank you. So that's what I was asking. So your assertion that the township made this decision for conditional use and applied these specifically for conditional use requirements, would you agree that doesn't hold true because it's applicable in all the situations where it's allowed by right or by special exemption?
Well, I don't think it's permitted by special exception anywhere, but I stand by my statement.
It is special, yeah, it's AO is special exemption. We read that.
Oh, you're right, the AO
Yeah,
district, I
thank you.
apologize. But my statement is that part of the reason why the commissioners require the larger lot size, a larger lot width, the deeper setbacks and so forth, is to be able to account for the fact that there are going to be impacts associated with the proposed use, and the township wanted to make accommodations for those, and not require, say, the same lot size as what's required in each of these zoning districts, where there would be no difference between having, on the other side of the property line, a single-family detached dwelling versus a small apartment building of senior housing, or what have you, whatever the uses under E10 and E12 might entail.
But you're actually countering what we just discussed.
I'm sorry?
You're actually countering what we discussed. There is no difference. If you look up E10 and E12, you look up the standard setbacks and so forth, it's exactly the same that is in the conditional use language. It's section of R1 and R2 and R3 and R4, correct?
Yes.
Okay.
But that's because the township wanted to account for the impacts of this proposed use, regardless of whether it's in a residential neighborhood or not. There are going to be impacts from use E10 and use E12.
Okay.
And the township wanted to ensure, to the best of its ability, that the uses could be made compatible with the surrounding properties.
Even if it's SIG, MSH is my point that...
That's correct.
Okay, that's fine. So let me ask you this. What you talked about there is that you mentioned that the front yard setback moves from 50 feet to 100 feet, correct?
In the R1 district, the front yard setback is 50 feet for single-family homes and 100 feet for uses E10 and E12, yes.
Okay. Compared to the side and rear yard, this is actually the greatest delta. And you can look it up. It's 50 and 30, so, or maybe it's 50. I'm saying that the 50-foot delta of the front yard is the greatest difference in setback between R1 and the E10 and E12 dimensional
I mean,
requirements.
single-family detached in the R1
Yes,
versus...
correct, yes.
Yes, that's correct in an absolute number sense, but not in a percentage.
Correct, absolutely.
Yes.
Absolutely. So help me understand. You're stating that, because your comment was that this is answering whether it's detrimental or not, that the township has applied these different setbacks and dimensional requirements, correct?
In part, yes.
Okay, so if it wasn't the case, it would be detrimental, right? You're saying there's a corollary there. You're saying it's not detrimental because there is these difference in setbacks, correct?
Yes, in part, that's
Okay.
correct.
So if it was at the R1 standard, it would be detrimental, is the logical.
It could be. I wouldn't say
Okay.
would be, I would say could be.
Okay, so help me understand. So we're talking about a 50-foot difference between R1 and the E2, or I'm sorry, E10 and E12.
Well, you keep saying between R1 and E2.
I'm sorry, no, I'm sorry.
E10 and E12. You mean single-family detached in R1.
Yes, I'm sorry. The
Versus
single family,
uses-
yeah, thank you very much. Single family attached in R1 versus what is standardly E10 and E12.
Yes, that's correct.
Are you stating that a 50-foot difference for this size facility, two buildings, 40-foot tall, one 20,000 square feet, one 11,000 square feet, that a 50-foot difference that if I'm on Durrell Road and it's 50 foot away, I'm like, this is horrible. It goes 50 more feet and I can't see it?
Well, first of all, that would be the side or rear yard setbacks, not the front yard setback.
No, the front yard is the 100, between 50 and 100.
Right, but that would only apply to the Woodland Road frontage, not to the property lines along Durrell Road.
Okay, so that's actually closer, you're saying?
Yes,
Okay, so then, thank you. Are you now saying that 30 feet away, 30,000 square feet of buildings, 40 feet high, so this is the length of this room, basically. So you're stating that if you're there and the building's right there, you're hating it, 20 more feet away, it suddenly becomes a non-issue?
I have an objection. I mean, I think we're debating at this point whether the ordinance is restrictive, and Mr. Babbitt didn't write the ordinance. His position and his statement on direct and on cross has been the Board of Commissioners determined that this use was permitted, and they added additional regulations. Provided that we meet those additional regulations, it's presumed it's not detrimental. He didn't decide that it was between 50 and 30 or 150.
Can I respond quickly?
Sure, go ahead.
But Mr. Babbitt, it was his testimony, specifically around whether this is a detriment or not, that said it is these setbacks that specifically change it from detrimental to non-detrimental. So
I
I'm
think
trying to,
Mr. Babbitt is saying their application meets the ordinance. And I believe that Mr. McHugh is right. Your questions are whether or not the ordinance as it's written is appropriate. And that's why we're going to sustain the objection. And you need to move on to your next question.
okay. So when you talked about further in your testimony, you mentioned the properties on Durrell, and you talked about elevation helping to hide this, I don't want to put, change the sight line, so forth and so on, correct?
yes.
Around it, again, detrimental or not detrimental. You aware there's 5 properties, 3 on Orchard Hill, the actual original property, and what we lovingly call the tower house that look down on this property?
From further to the north, uphill?
So Orchard Hill, there's 3 property, I'm not even including
Oh,
me.
you mean on the street named Orchard Hill?
Yes,
Oh,
street
okay.
name Orchard Hill, there's 3 properties up top that are actually at a higher elevation, the actual original property.
Yes, I was aware that
Okay.
they are higher elevation. They're comparable elevation to the manor home that's on Lot 1 here.
So when you talked about your buffering and things, how does that help the folks that look down on it?
Well, to a degree, it means that the people who live on this cul-de-sac will be able to look out from their decks, their windows, what have you. Instead of looking at a building, in many instances, they're going to be looking over the building. Because the building is going to be at a significantly lower elevation than their homes.
So doesn't that make it easier to see? Because you've talked about buffering, you've talked about setbacks.
Right?
They're, I don't know what the right term is, planar? On a level plane? You talked about Durrell being at a lower plane, that being beneficial. If I'm on a higher elevation, as I move the building around, I'm still going to see that building, correct?
Yes, you will, but I would suggest that it's also beneficial to the people on Orchard Hill Lane because they will not be looking directly at a building that's on the same elevation as their homes. They will be looking over the proposed buildings, or at least to a degree over the buildings because of the change in grade in the area.
So you think it's beneficial to these folks that that they're looking down on it, so I'm assuming on top of these buildings, there's air conditioning units, mechanicals, things of that nature. You're saying it's beneficial that when they look down on the building, they see a more industrial view than on a level, is what you're saying?
No, I'm suggesting that instead of looking directly at a building, they have the opportunity to look up a little bit, and they're maintaining their long views of distance, and that's
So,
what they would see.
okay, help me understand this. So, talking about elevations, talking about this, you're suggesting people just look away.
No, I'm suggesting that the change in elevation actually is a benefit to the surrounding property owners because the proposed buildings are not at the same elevation as very many of the existing homes in the area. It's the homes that are at the same elevation that would be looking out their windows directly at another building. In the instance of, I believe, Dorrell Road, those properties are lower. If they look out their windows, probably what they're seeing most is going to be a hillside in their backyards, probably the same hillside they've been seeing since they've moved in, instead of, again, a new building in the distance. They're going to be looking at their own backyards, the slope that goes up to the property line and the existing vegetation, and even the proposed vegetation that's proposed for this property.
So help me understand, you literally just testified that the people in Orchard Hill that are looking down, that the opportunity they have is to, I think, determine.
Okay, I'm going to stop you, Mr. Booth. We are beating this to death.
Okay.
Okay,
All right.
please move on.
Okay, that's fine. Appreciate that. One other thing, and I'm just going to ask, you talked about buffering. Talk about, and I think, I don't want to screw this term up. You said that the applicant, I don't think you said hell, is going to landscape the heck out of this place, correct?
Yes, that's correct.
Okay, sorry if I. I'm sorry. And you're using that as, I'm assuming, a positive for the applicant, saying that this is going to, again, hide the building, make it less visible, whatever the case may be. Is that what you're doing with buffering?
No, I don't suggest it's going to completely hide the building, but I do think it will buffer the view of the proposed building from
Buffer
the
the view of the
surrounding
building.
properties. Yes.
Okay. Oh, sorry. I just said yes. Yeah, okay, sorry. So it's going to assist in the not seeing it or seeing it less or whatever term you want to use, correct?
The term I would
Okay.
use is to buffer it, yes.
Yes. So you said, obviously, the comment you made, and again, you can look that up, obviously, they're not going to be the same size, at least not when they're planted, but eventually they will. Sorry about that. Is that correct?
Well, trees, when they're planted, typically are 4, 5, 6, 7, 8 feet in height. Typically, trees, when they're planted, are not 30 or 40 or 50 feet in height, but many of those trees will reach that height or even higher sometimes. And when they are mature trees, they will provide a greater buffer from the surrounding property owners, yes.
So for the current time period, and I don't think on the conditional use, there's no time period that says, well, it can meet conditional use down the road or so forth. So if the folks on Durrell and the folks, there's another property on Woodland that abut the property, if they find it detrimental seeing the building, your statement is eventually over time that will get cured, correct?
Well, I don't know that I'd use the word cured. I will say that over time, their view of the property will be increasingly buffered by vegetation that's going to be planted, yes.
Right, so you're agreeing with, so if they're finding it detrimental now, then that will.
Well, I don't know what people are going to find detrimental now versus then. My guess is that some people are going to find any development on this site detrimental now and forever, regardless of what gets built there, even if it's a single-family home.
So, if I understand the conditional use correct, there's 4 conditions that have to be met, correct?
I believe there's a lot more than 4, yes.
I think there's the four it could be, there's the four primary, and I could be reading it wrong, and I apologize.
Well, there's 4 under section 1806B.
1806, yes.
And
Okay,
there's,
thank you.
but there are another, 1, 2, 3, 4, 5, 6, 7 under paragraph G. So those are different.
Okay, yes, they're
standards.
different, yes.
So it's not just 4.
Okay, thank you. And the four listed, the 1806 section,
Well,
there's,
they're all under 1806. You mean
Okay,
1806B?
thank you, 1806B. This is not pass-fail, correct? Like, so this is not, of those four, it's not 3 out of 4 have to be met. All 4 have to be met, correct?
I'm
Yes,
going
sir,
to
that's correct.
object into the extent that, I don't know, I mean, relevant to the extent that, Mr. Clark, you're going to make a recommendation, you know what the conditional use criteria and law are, and the board certainly does when they're going to make their
Okay.
decision. I don't know that Mr.
Last question, and I'll
Okay,
answer that.
So I'll sustain that objection, and then you can ask your last question.
Okay. So you just stated that the people in are going to find it detrimental.
I think some people are. I think some people don't like change in their neighborhoods. I fully understand that. I've seen it before many, many times. And that change could represent even the construction of one single-family detached dwelling, up to the construction of a senior housing facility.
But isn't the condition we talked about under 1806B that it's not detrimental?
In my view, the opinion of a neighboring landowner, a resident, is not what constitutes what is detrimental. What constitutes detrimental is what's in the ordinance. And if the application meets the ordinance, if it meets the minimum lot size, lot width, lot depth, setbacks, building coverage, impervious surface coverage, open space, height requirements, everything down to the steep slope provisions, floodplain provisions, if that's applicable, if it meets all of the requirements of the zoning ordinance, then by definition, it would not be detrimental.
But the language of detrimental talks specifically about the properties.
Again, I think the language, to me, I read this by the commissioners are making the judgment as to whether a development, a proposed development would be detrimental to the neighbors. They're not simply going out and querying the neighborhood as to say, do you want this development or not? That is not how the conditional use process works. It is a conclusion, a decision made by the Board of Commissioners, certainly with input from neighbors and input from experts and input from staff and so forth, but it is not simply the subject of an election. Let's survey everybody and see who wants this development and who doesn't. That's not how this process works. And
Okay.
again, by definition, if the application meets the ordinance, the presumption is that it's a valid application and it does not, that it is generally consistent with the health, safety, and welfare of the community. And that is a generality, but as I like to tell my kids, the funny thing about generalities is that they are generally true. And that's the system we work under. If the application meets the ordinance, it needs to be approved by the governing body, not just this township, any
Right,
township.
but the ordinance has conditions, that's why it's called, so in other words, the township is not saying every one of these is applicable. That's why it's called conditional use, correct? If not, it would just be a yes under full right to have it in R1, R2, and R3, and R4.
That's correct, but the conditional use does require every one of these conditions be met, but it doesn't require that there be a plebiscite in the neighborhood taken as to whether they want this development or not. That's a judgment for the Board of Commissioners, not just for the neighbors.
Informed upon by the actual neighbors themselves.
Absolutely, but again, the presumption is that if the application meets the ordinance, the presumption is that the application is generally consistent with the health, safety, and welfare. And if anyone wants to disagree with that, they would have to prove that there is something particular, something different, something unique about this application that goes above and beyond what a typical application for uses E10 and E12 might entail. And I do not see that there are any such unique circumstances. We're not proposing a skyscraper senior living facility. We're not proposing a facility that handles radioactive waste.
Right. So
or
when
anything
we,
like that.
so when you offered the one piece of evidence about it not being detrimental, the code says that the applicant has to provide the proof that it's not detrimental.
And the proof would be, in general, compliance with the ordinance, the specific standards of the ordinance, which I believe we have done.
I don't want to be snippy, but do you understand the definition of the word detrimental, meaning that detrimental means a negative impact?
I'm going to object.
Yeah, and again, we're going round and
All
round.
right.
And I think he's answered your question multiple times,
All
so
right.
thank you.
That's all I've got, thank you.
Okay, it's 9:38. Can I have a show of hands of how many people are intending to question Mr. Babbitt? Okay, there is no one in here who intends on questioning Mr. Babbitt. Okay. Mr. McHugh, do you have redirect of Mr. Babbitt? And Mr. Heleniak, will you be questioning Mr. Babbitt?
No, I'll note for the record that the township has no questions for Mr.
Okay.
Babbitt at this time.
At the risk of reopening everything, I don't think I have any other questions.
Okay. So we are done with Mr. Babbitt. And we had originally scheduled and discussed at the last hearing that our next hearing would be on next Wednesday, the 22nd. That was with the anticipation that we would, and Mr. McHugh, Mr. Babbitt is your last witness.
That's correct. I mean, I guess at this point, I don't know if you want to handle housekeeping, but I would,
Yeah, I don't think,
Okay.
yeah, we'll do exhibits and things like that later. That was with the anticipation that we would possibly not get through Mr. Babbitt this evening, which we almost didn't. So we are not going to use that April 22nd date. The next date, the next two dates we are looking at, and understand that much of this is driven by Penn State, because we feel we need to move this back over to Penn State. The next two dates we're looking at are, give me 1 second here, Wednesday, May 13th at 6:30 p.m. at Penn State, and Thursday, June 4th at 6:30 p.m. So the next hearing date is Wednesday.
May 13th does not work for me.
Okay. That, as of now, the next date, the next scheduled hearing date is Wednesday, May 13th at 6:30 p.m. We will ask that any requests for continuances be made in writing in the next couple of days, and then we will look for other dates. But as of now, so we don't have to go through the whole re-advertising, the next hearing date is Wednesday, May 13th at 6:30 p.m. at Penn State. What we're going to ask everyone who has party status to do is in the next, we'll say by next Friday, the 24th, to email Mr. Heleniak and indicate to Mr. Heleniak whether or not you intend on presenting testimony and what that testimony will consist of. Essentially, are you going to be calling witnesses, or are you going to just be presenting your own testimony? At that time, we will make a determination of what order we are going to go in and who will be presenting first at the next hearing. If we are able to get through all of the testimony at the next hearing, which my guess is unlikely, then the June 4th date, we would be looking at closing statements and public comment. If we are unable to get through all of the testimony, then we will continue it on to June 4th, and then we will be looking at another date for closing statements and for public comment.
Mr. Clark, if I can be heard, as a member with party status, the neighbors are working very hard to coordinate which witnesses will present in which order. So I would object to you or Mr. Heleniak determining which order we should present witnesses in.
So we're more than happy for you to present us with a proposed list that's agreed to. As you know, Mrs. Wellheimer, the rules are a little bit more relaxed here. I can kind of determine who goes next. So if a large group of residents say, this is the order we want to go in, I can see no reason why I wouldn't agree to that. If we don't have a lot of people who are in agreement on that, we'll try to do it the same way. But I would much rather you all agree on who's going to present and what and in what order. That would just make it easier for all of us. There's a hand in the back. Please identify yourself. Please come forward so you can be heard.
Dan DeVore, party status, Rydal Road. Last name D-V-O-R. May I ask Mr. Babbitt a question? I know you asked if there was any questions. I was just listening and processing. I had one clarifying question to ask.
Do you object, Mr. McKeon?
It will be, I think, within 3-4 minutes, and it should be answered.
It's a 3-4 minute question, I don't know, but no, that's fine.
No, I'm saying the question will last 3-4 minutes. The total discussion will last 3-4 minutes.
Okay, go ahead.
Okay, excuse me. I was just looking at like the conditional use, and there were like 4 parts that were mentioned before, and I think you did I think you explained the whole part of detriment, how if it fulfills the ordinances. The second one in this conditional use is consistent with the spirit, purposes, and intent of the applicable zoning district. In terms of what you were talking about with the detriment, if it fulfills the ordinances, how do you judge that second part? How do you judge if it fulfills the spirit, purposes, and intent of the applicable zoning district?
By having a knowledge of what the zoning district includes, what it permits, what it does not permit, and if a zoning district permits the uses that are being proposed, then I think it would be very difficult to say that the zoning district, the intent of that, purpose of that zoning district, the spirit of that zoning district, does not include the proposed use. The proposed use is, after all, a permitted use. Both proposed uses, E10 and E12, are both permitted in the R1 district. Therefore, I reach the conclusion that the application meets the spirit, purposes, and intent of the R1 district because they are permitted uses. Even if they are not specifically enumerated in the intent section of the R1 district, they are still, I believe, consistent with the spirit, purposes, and intent of the district.
Because they're allowed they're allowed.
That's exactly right, because they are permitted uses in the district.
Okay.
How can a district permit uses and at the same time have the intention of not permitting those uses? That does not make sense.
And in terms of like what Gail was talking about, how there's like different years, like 2000, 2007, 2010, how that changes, does that get updated, or that's for the commissioners to decide?
I'm sorry, does what get updated?
So the allowed uses, they seem to change as the decades go on. So,
Yes, the Board of Commissioners is the one ultimately responsible for adopting the zoning ordinance and amending the zoning ordinance from time to time. They're the only ones that can adopt and amend the zoning ordinance, with the possible exception if they're ordered to do so by a court, I suppose. And I'm confident that the Board of Commissioners in Abington Township will continue to amend the zoning ordinance as it sees fit. I do not believe that the elimination of the E10 and E12 uses in the R1, R2, R3, and R4 districts by itself signifies that there's no longer a need for senior housing in this township. In general, the demographics of the country are that the population is aging, and those of us who are reaching senior status, as I will in just a few months, we're going to need housing for ourselves and our cohorts, our age cohorts, and that's going to be true regardless of what may be a fluctuation in the percentage of the population of this particular township at any one moment in time. until we see a significant demographic change in the population of not just the township, but the region, I still maintain that there will be a need for senior housing in Abington and elsewhere.
Thank you.
You're welcome.
Okay, with that, it's 9:47, and we are in recess until Wednesday, May 13th at 6:30 PM at Penn State University. Thank you.